Next week, they'll give a date. EVRಗೆ ನೋಡ್ರಿ 2022 ರಿಲಿಸ್ಟ್. Realist. On 14/10/2024, this court will granting while issuing notice to the respondent and grant an interim stay. However, it was noticed thereafter that no application for interim stay had been filed. Consequently, there shall be no interim stay. Issue notice, SCGB accepts notice for respondents 1 and 2. So interim stay as prayed for. To notice, SCGB accepts notice for respondents 1, 2, 3. Post along with this interim stay of the interim order. ಮಾಡಿದನಲ್ಲ ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ, ಬರ್ದ್ರೇನೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವ್ರು ಬರ್ಲಿ, ಅವ್ರು ಬಂದ ನಾನು
blood.
When did you initiate the proceedings? Then, after how many years? No. From the date of the act itself, 30 years.
Yes.
Yes, ma'am.
Blood, I appeal for the respondent, blood. Contesting respondent.
The act came into force in 79.
Yes.
If you initiate proceedings in 2011, after 30 years, ಏನಾಗಿರ್ಲಿ ಡಿಲೇಗೆ ಹೇಳಿ 31 years. No, you made the application for resumption when? When did you make the application for resumption?
Lord, in 2010-11, Lord. Lord, synopsis of dates is there, Lord. My colleague is there. If you Lord.
30 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರೆ ಏನ್ ಇದಿಲ್ವಾ?
Application made in the year 2010, my lord.
10-11, yes.
10 and 11.
PTCL Act apply ಆಗಲ್ಲ ಸ್ವಾಮಿ.
Consent ನೀವು ಕೊಟ್ಟರೆ ಬಿಟ್ರೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋಗಿದೆ. You are granting consent to the transfer made earlier. That is the cause of action for you, not the consent deed. How can I ignore the 30 years delay? ಮಾಡ್ಕೊಡಿ ಏನಾರು. ಮೇಡಮ್ ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಬೇಕಂತ ಮಾಡ್ಬಿಡಿ.
Lord, they are really harassing, Lord. I'm sorry to say this, Lord.
Every case is harassment, madam, in SCST. There's
Lord,
no difference.
He is not even a legal heir of the grantee.
You obtained a consent deed from him.
Lord, it's not me, Lord, someone else.
Settle
That
ಮಾಡ್ಕೊಡಿ
has
ಸುಮ್ನೆ.
become a trump card for him, Lord, for settlement. Lord, if Lord
ನೀವು-
may kindly see 1940 grant.
ನೀವು ಒಬ್ಬರು ಕೊಟ್ರೆ ನೀವು ಒಂಥರ ಹೆಬ್ಬಾವನೆ ಬರೆಸ್ದಂಗೆ.
ನಾವು ಕೊಟ್ಟಿದ್ದಲ್ಲ, ಬೇರೆ ಯಾರೋ ಮಾಡ್ಕೊಂಡಿರೋದು. Lord, he is misusing the Lord, the caste. I'm
Everybody
sorry
is
to say that.
misusing the act.
Please, Lord. Lord, you
So
Lord
this-
may
this
kindly
is-
see 1940 grant PTCL Act ಬರೋದಿಲ್ಲ.
ಯಾಕೆ?
ಇಲ್ಲ ಬರುತ್ತೆ.
Land revenue grants ಅಲ್ಲಿ ಬಂದಿರೋದು ರೂಲ್ಸ್ ಅಲ್ಲಿ 10 years non alienation period. After the non alienation period I have
Permanent alienation ತಾನೆ, permanent non-alienation ತಾನೆ.
ಇಲ್ಲ 10 years non alienation.
If that amendment act is made applicable, then this question of delay will not come into play.
But that the division bench has already said, Lord, the amendment would not come in the way of the Nekanti Ramalakshmana
Read the judgment carefully. It says both ways. Nothing is decided there.
Lord, it's not that way, Lord. Your Lordship may kindly appreciate.
ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರಿಗೇನೋ ಸೆಟಲ್ಮೆಂಟ್ ಬೇಕಂತ.
No, Lord, I'm sorry, Lord. Your Lordship may kindly decide it on merits.
ಇಲ್ಲ ಅಂತ. Realist. ಏನ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಮಾಡ್ಕೊಳ್ಳಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೊತ್ತಿಗೆ, ಆಮೇಲೆ ಇಲ್ಲ.
29th.
Grateful.
Bill number 5. Shri Srinivas Bibi.
ಒಂದ್ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಲ್ವೇ? ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? ನೀವು ಮೇಡಮ್ ಇದೆಲ್ಲ ಸೈಟ್ಸ್ ಏನು?
Correct, my lord. Sites, my lord, it's come under, my lord. AC order ಅಷ್ಟೇ ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. And they should go before the DC, my lord. Alternative remedy ಇದೆ.
You not gone to the DC?
No.
Next year? Next year, next year? Page. ಏನಿದೆ? ಹಾ.
Correct. Shall resume their sites formed subject to the assistant commissioner ಅಂತ ಕೊಟ್ಟಿದ್ರು. Assistant commissioner ಆರ್ಡರ್ ಇದು ಮಾಡಿದ್ರು. ಇದೆ assistant commissioner ಇದು ಮಾಡೇ ಇಲ್ಲ. My lord, page annexure K ಅಲ್ಲಿ in page 97, my lord.
You are prepared to pay the market value to them.
That they have to comply, my lord.
ಅಲ್ಲ ನೀವು ಈ ಆರ್ಡರ್ ರಿಲೈ ಮಾಡ್ಕೊಂಡ್ರೆ
Yes.
then you will have to pay market value to the LRs. ನಿಮ್ಮಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಅದೇ that's what they has not given any information, my lord. ಹಾಕಿದಾರೋ ಇಲ್ಲೋ nothing. They have not produced anything.
Next week. I think if
They have to
you
go
prefer an
before the
appeal,
assistant commissioner and they have to pay the whatever they determined.
ಇಲ್ಲಾಂದ್ರೆ AC order ಮೇಲೆ I can't entertain rate petition.
29. Number 6, Sri Joseph Sebastian.
Condition being when lost to pay the market price. They agreed when lost was 2 lakhs. The value of the property was 12 crores. As per the same. And has to be purchased. The alternative land and lawsuits there, because the litigated land, the mineral agreement.
You are for the granting. You secured permission
I did my loss.
and then sold the land.
I appealed to DPM and not as per the sale agreements. Subsequently, my loss, voting the executors my loss, give me order the approach the competent authority for their commission. Their commission was granted within a span of 34 days. It is not signed by the principal secretary or the commissioner. It is just my loss approved by the undersecretary.
But thereafter you executed a sale deed, got the consideration.
However, on the basis of the DPM method, the property saving executed no consideration part of it. Thereafter, my law of the guys, because the renewal no method, I am not secreted to say. They take me to the substitution office and the guys getting a confirmation deed to this term. Agreed to pay a sum of rupees 4 crores, my loss, they paid some of rupees 4 lakhs. That is that.
How can you invoke PTCL Act?
My loss is sale.
If you admit that you have executed a confirmation deed, you are therefore ratifying the sale deed that was executed. You therefore confirm the fact there was a prior permission granted.
The fact is that the alternative property has to be purchased, even by the sale,
The sale will not be bad. The sale will not be bad.
well, the condition has been violated. Condition in the official memorandum states that an alternative property may also have to be purchased in my name. The car has to be transferred into my name.
That
Only
is-
then my loss, this particular property.
That can't be a ground to invoke PTCL Act. PTCL Act, if you have executed a confirmation deed, what is that can be done? That is a problem. If you have executed the confirmation deed, you are doing two things. You are ratifying the sale deed done earlier. All right. Thereby, you are also ratifying the fact that permission was granted under 4.2.
Conditions in the permission may also not refer to what I'm saying.
There's a judgment of this court saying that non-adherence to those conditions will not be a ground to set aside this.
I'm not sitting on the condition. Conditions are not being adhered to.
Who knows who has received consideration, who has not received consideration?
Otherwise, because the official memorandum was very changed, that the consideration
That
has to
can't-
be by way of account paycheck, not even a single penny may loss by way of account paycheck or a DD may loss.
Where is that permission?
Page number 26. Page number 26. Condition number 10. Condition number 10. You try to loss. The amount that has to be part of loss has to be by way of account paycheck alone. Condition number 11 may loss. Another alternative property has to be purchased. Condition number 12 may loss.
You have violated that condition. You have violated the condition. Permission was given to you to sell. Subject to condition that you purchase the property and you receive the amount by way of a check. If you do not abide by that conditions, how can you take advantage of this?
Perhaps any efficient factor, sale agreement with the people, they have entered into a sale agreement by law, with a person who does not hold right to the property at all. And condition number 12, this is one condition number 12. nobody states, only once the other property in my law, the alternative property is transferred into my name, not admitted into my name.
Who secured this permission? You secured. If you-
It is only on the basis my laws of.
Aren't you stopped from saying this now? After executing the confirmation deed?
That's the whole point, my lord. The people are taking for task.
My lord, page 98, my lord. They produced the alternative land agreement. Yes, my lord. My lord, even in check, my lord, they have produced page 98, my lord, it says. ಅರ್ಜಿದಾರರು my lord, may I read third paragraph, my lord. ಸದರಿ ಜಮೀನು ವ್ಯವಸಾಯ ಮಾಡಲು
98.
ಯೋಗ್ಯವಲ್ಲದ. Yes, my lord, page 98.
98 is sub-registrar ಏನು endorsement.
ಇಲ್ಲ, ಸರ್ಕಾರದ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಗಳು ಅಂತಿದೆ my lord. ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಆನೇಕಲ್ ತಾಲೂಕು ಸರ್ಜಾಪುರ.
Next year ಏನು?
Annexure, yes, my lord.
Yes.
Yes, my lord. Annexure is, my lord, ಅರ್ಜಿ third paragraph, my lord. ಅರ್ಜಿದಾರರು ಸದರಿ ಜಮೀನು ವ್ಯವಸಾಯ ಮಾಡಲು ಯೋಗ್ಯವಲ್ಲದ ಜಮೀನಾಗಿದ್ದು ಕುಟುಂಬ ನಿರ್ವಹಣೆಗೆ ಹಣದ ಅವಶ್ಯಕತೆ ಇರುವುದರಿಂದ ಪ್ರಶ್ನಿತ ಜಮೀನು ಶ್ರೀ ಗೋಪಾಲ್ ನಾಯ್ಡು ಮಾಡರ್ನ್ ಮೆಲಡ್ ಸೋ ಸರ್ಜಾಪುರ ಮುಖ್ಯ ರಸ್ತೆ ಬೆಂಗಳೂರು ಮಾರಾಟ ಮಾಡಲು ಕ್ರಯದ ಕರಾರು ಪತ್ರವನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ತದನಂತರ ಸರ್ಕಾರದ ಇತ್ತೀಚಿನ ಸುತ್ತೋಲೆಯ ಪ್ರಕಾರ ಪ್ರಶ್ನಿತ ಜಮೀನಿಗೆ 62 ಲಕ್ಷ ನೀಡಲು ಒಪ್ಪಿದ್ದು ಈಗಾಗಲೇ ರುಗಳನ್ನು ಚೆಕ್ ರೂಪಗಳಲ್ಲಿ ಖರೀದಿದಾರರು ನೀಡಿರುವುದು ಕ್ರಯದ ಪತ್ರದಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಕ್ರಯದಿಂದ ಬಂದ ಹಣದಿಂದ ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬಿದರಳ್ಳಿ ಹೋಬಳಿ ಹೂವಿನಾನಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 41ರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಶ್ರೀ ದೊಡ್ಡಯ್ಯ ಬಿನ್ ಮುನಿರಾಜಪ್ಪ ಅವರ ಪರವಾಗಿ ಜಿಪಿ ಹೋಲ್ಡರ್ ಪ್ರೇಮ್ ಕಿಶೋರ್ ಡಿ ದೊಡ್ಡಯ್ಯ ನಂಬರ್ 44 ಅದೂರು ಸೋನ್ಸೋ ಇವರಿಂದ ಖರೀದಿಸಲು ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ರಂದು ಕ್ರಯದ ಕರಾರು ಪತ್ರವನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. My lord, they made the agreement and afterwards, my lord, they sale deed also they might have done. I'll produce that, my lord, very
You have
well.
taken 21 lakhs by way
Yes.
of check.
Yes.
You should have been careful.
No, but this next page, the agreement of sale itself is the vendor request.
Circle.
This is the page 126. This is the agreement of sale.
The problem is I can't go into all this in a PTCL proceeding. PTCL Act can be invoked only if there's a sale without permission.
Yes.
If there's permission and the permission conditions are violated, this is not a ground under the PTCL Act to resume the land. On what basis do I say? What do I say now? No. What is the order that I can pass?
See, my lord, if I see the law, single total the law, 21 lakhs plus another 4 lakhs. For property by law, which is almost 5 lakh crores. Apart from that, when you look at the articles that released the next week, there is a court litigation property. This is the property matters they have written. Ultimately, my lord, illiteracy, my lord.
No illiteracy, no illiteracy, nothing of that kind. Who knows from whom you have taken money and
Otherwise, my lord, what is recordingly stated there is only a sum of rupees 21 lakhs, my lords. In addition to that, 4 lakhs, my lords, under the confirmation deed. If you add to the confirmation deed, my lords, they mentioned 4 crores. In lubricants, and my lords, what is it?
you can't convert a writ court into an executing court.
What would be validity, my lords? That's the whole.
Nothing. If your remedy is to go to the civil court and say that you have not received the sale consideration mentioned in the sale deed, for which you have to pay court fee.
Please, my lord, that is sale price or.
Can that be a ground to set aside the sale? You have to adhere to the conditions, not them.
No, my lords, the sale has to be executed only, my lords, in the event. If, my lords, the property is transferred into my name, before that, my lords, the sale was executed. In fact, my lords, there is direction given to suppress from my lords.
Nobody forced you to execute the confirmation deed.
Taking my lords, the base. Sale was not executed by me. It was executed on the basis of the GPA.
ಏನ್ ಕಾಸು ಬಂದಿಲ್ಲ ಮೇಡಮ್ ಅವ್ರಿಗೆ?
But that we can't say, my lord. Civil court go, my lord, let them, see, that is not the duty of the, my lord, officers, my lord. They have received the amount so and so and they produce all the agreements, my
But
lord.
what is the,
Checklist, whatever we asked. my
what is
lord.
the effect of issuing such a conditional order? Don't you have to verify whether this condition is complete with
My
or
lord,
not?
checklist we have verified, my lord. That's what page 98 ali. Further, he says, my lord, all the mutation, Kararu Patra, Jati Pramana Patra.
Lala,
Yes, my lord.
conditions, ಈ ಪ್ರಾಪರ್ಟಿ ತಗೋಬೇಕು,
Correct.
ಡಿ ಮುಖಾಂತರ ತಗೋಬೇಕಂತ ನೀವು ಕಂಡೀಷನ್ಸ್ ಹಾಕಿದ್ರೆ,
Yes, my lord.
you don't have to comply, see whether it's complete or you blindly keep it.
We'll verify, my lord. We'll authority.
ಮಾಡಿದ್ದಾರೆ.
Kararu Patra ಕೊಟ್ಟಿದ್ದಾರೆ, my lord. And
ಕರಾರ್ ಪತ್ರ ಆದ್ಮೇಲೆ
sale deed has executed or not. I can verify, my lord, is that they are produced or what. Alternative land, they have purchased the land or what.
ನಿಮ್ಮವರು ಶಾಮಿಲ್ ಆಗಿ ನೀವು
ಅದೆಲ್ಲ civil, my lord, it is in civil in, my lord. They
I
have
get the feeling that this is a package deal
yes.
where the purchaser will come, he'll say, I'll get you permission and do all this necessary things. ಅವ್ರಿಗೆ ಎಷ್ಟು ಬರ್ತದೆ ಅವ್ರು ಮೂರು ಜನಕ್ಕೆ ಮಾರಿರ್ತಾರೆ.
Yes, my
ನೀವು ಅದಕ್ಕೆ ಶಾಮಿಲ್ ಆಗಿ
my lord, authorities, my lord, here no
No, if
hands,
he
my
has
lord, where to
granted,
get.
is granted such detailed conditions,
Yes, my lord.
should he not at least verify whether it is complete with or not?
I'll verify, my lord, definitely, my lord, without checking the all the list, my lord, they don't give the any permission. I'll verify that and I'll get back. Otherwise, my lord, all this has to go through by civil court, my lord. Ellen forge signature ಅಂತ ಹೇಳ್ತಾರೆ. We have not received ಅಂತಾರೆ. Go through detail means, my lord, not in writ proceedings, my lord. Let them go to
Yeah,
civil.
that is the loophole that they are trying to find. They get permission,
Yes, my lord.
they don't abide with the conditions, and you also keep quiet.
I'll say.
And I will dismiss the petition on the ground permission, right or wrong, is granted.
My lord, is that all that documents checklist they verified or not? I'll produce that whatever the requirement documents they produce me. 1 to 5, I'll take notice, my lord.
Give accepts notice. 1 to 5. Issue notice to R6 and R7. Council is permitted to take out notice on R6 and R7 personally and inform that the petition will be taken up for disposal on. Yes. You have 0 case according to me. But if they come forward and voluntarily pay something, take it and go. You want to argue on merits, you'll get a dismissal today.
Stay ಆಯ್ತಾ?
6th December.
Stay.
6th.
Stay ಆಯ್ತಾ? ಇಲ್ಲ.
6th December. Seal number 7. Sanjay Krishna V.
Two 2010, madam, 30 years.
Yes, my lord.
CGV accepts notice.
1 to
for
3 I'll take.
respondents, 1 to 3. Issue notice to respondents 4 to 9. There shall be an interim stay. You don't want notice to them. As requested notice to R6, R7, R8 and R9. Expense bill. Issue notice only to R4 and R5.
For orders, seal number 8. Sri Dixit. The last occasion as a last chance, a week's time was granted to the needful. Or needful has not been done. You have to know the alternative. Petition is dismissed on.
Seal number 9, Sri Chanbasappa.
The last occasion, a week's time was granted to the needful. Or needful has not been done. You have to know the alternative. Petition is dismissed on prosecution.
Seal number 10, Sri Rudrappa.
ಯಾರಿಗೆ ಯಾವಾಗ ಮೆಮೊ ಹಾಕಿದಾರಾ? ಅವ್ರ ಹೆಸರೇನು? Memo is filed stating that the copy of the petition was served on Kantaraju V. The counsel will represent the respondent in the trial court. Office to print his name in the cause list. When is the case posted there? ಅಲ್ಲ ರೂಲ್ ಯಾವತ್ತಿದೆ ಪೋಸ್ಟ್ ಆಗಿರೋದು? ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಲಿಸ್ಟ್ ಅವ್ರು ಒಂದ್ಸಲ ತಿಳಿಸ್ಬಿಡಿ ಅಮ್ಮ ಅವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ತಗೊಳ್ತೀವಿ ಅಂತ ಡೇಟ್ 13 ತಗೊಳ್ತೀವಿ ಅಂತ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರು.
Number 11, Shri Sumantel Bharadwaj.
ಇಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ? What does the husband do? You had filed MC 54 about 2022, na? ಏನಕ್ಕೆ? ನೀವ್ ಹಾಕಿರೋದು ಅವ್ರು ಹಾಕಿರೋದು ಯಜಮಾನ್ರು ಹಾಕಿರೋದು? ಡಿವಿ ಆಕ್ಟ್ ಎಲ್ಲಿದೆ? ಡಿವಿ ಆಕ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲಿದೆ? ಬರಲಿದೆ ನಂಬರ್ CMS ಏನು 59 ಬಾರ್ On 7/3/2024, petition was permitted to take out notice on the respondent through his counsel in the trial court. A memo was filed indicating that the process that was indicating that the copy of the petition was served on the respondent's counsel. Next, on 8/11/2024, the petitioner was directed to inform the respondent's counsel the matter will be taken up for disposal on 15/11/2024. And the matter is called today. There is no representation on behalf of the respondent. It is therefore obvious that the respondent has no objection for the petition being transferred. The wife is seeking for transfer of MC 56/2023, which has been issued by the husband for restitution of conjugal rights before the senior civil judge and JMFC at Sakleshpura to the court of the senior civil judge and JMFC at Somarpet, where the petition that she has filed for dissolution in MC 54/22 is pending adjudication. In view of the fact that the wife had already preferred a petition seeking for dissolution, and it is also stated that she has filed one more petition under the provisions of the DB Act in CMS 59/2022, it would be appropriate to withdraw MC 56/2023 and from the court of the senior civil judge and JMFC Sakleshpura and transfer the same to the senior civil judge and JMFC at Somarpet. Senior civil judge and JMFC at Somarpet is directed to ensure that MC 56/2023 and MC 54/22 and also CMS 59/2022 are posted on the same day. Petition is accordingly.
Number 12, Shri Sriram Babu.
Who's respondent 5? Indigent person, Respond number 6 here. Office objection regarding arraying of the state and the deputy commissioner as fifth and sixth respondent is deferred. A week's time is granted to comply with the remaining office objections. So in the meantime, issue notice to respondents 1 to 4. So the Tahsildar is also directed. Yeah, madam, Tahsildar east ಇದು ಯಾವ್ದು ಬರುತ್ತೆ? ಇಲ್ಲ, ಅದು ಯಾವ jurisdiction ಬರುತ್ತೆ? ನಾರ್ತ್ ಏನು? ಕೇಳ್ಕೊಂಡು ಆಮೇಲೆ ಹೇಳಿ. The Tahsildar so and so is directed to Tahsildar Bangalore North is directed to submit a report regarding the solvency of the petition. Released on 2 weeks on date.
6th December. 6th December. Number 13, Sumantel Bharadwaj.
ಅಲ್ಲ, ಅವ್ರ ಹೆಸರನ್ನು ತೋರ್ಸಕ್ಕಾಗಲ್ಲ ನಾವು, ನೀವು ಹಂಗ್ ಮಾಡಿದ್ರೆ. Until you file the memo indicating the name of the counsel. Tomorrow they'll come and say that I was not received. Counsel is granted a week's time to file the acknowledgement for having served the copy of the petition on the respondent's counsel. Office to print the name of the respondent's counsel in the cause list. ಅವ್ರ ಹೆಸರು ಬರೆದು ಕೊಡಿ ಕ್ಲೀನ್ ಆಗಿ, ಯಾರು the list.
29. Number 14, Shri Prasanna VR.
Waive publication in respect of R4, accepted R4 called out. There is no repression, hence R4 is placed ex parte.
Appearing for respondent number 2.
2700 days delay na.
Earlier, I was impleaded not, sir. Insurer will not file applications before the proceeding. Stating that insurer goes on the first point, but insurance policy was with respondent number 33. But therefore, I was impleaded. Though not transfer the vehicle. Then not, sir.
Transit vehicle to whom?
The first respondent. He is not the present court respondent. First respondent was the insured owner before the against.
Jaishila was the registered one, ka?
Both respondent was Gautam.
Gautam.
Registered owner as on the date of accident. But I was the previous owner.
When did you sell the vehicle?
Additional document along with an application. Percent agree.
What is the date of the accident?
The date of the accident.
21/6/2010, Miraj.
The 22/2008 in the synopsis.
Date of the accident was 20th February 2008.
Oh, sorry, Miraj.
And when did you sell the,
29/10/2007 vehicle was sold.
and the insurance policy was valid from?
Policy valid. But as on the date, insurance policy was valid, but PN rate was not covered.
Act only policy, Miraj.
Therefore, I have to reach out.
Did you inform the RTO?
I have informed the RTO. RC was also not covered.
When was RC? Then why did the trial court fasten liability?
See, the policy was in my name, that is the reason assigned to us by the trial court.
I'll only make the fourth respondent liable.
ಅವ್ರು ನನ್ನ ಮೇಲೆ ಲೈಬಲ್ ಇದೆ, ಆಕ್ಟ್ ಪಾಲಿಸಿ ಅವ್ರ ಮೇಲೆ ಲೈಬಲ್, ಯಾಕಂದ್ರೆ 157 ಇಟ್ ಇಸ್ ಡೀಮ್ ಟು ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ RC ಬುಕ್ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದೆ ಅಂತ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಇಟ್ ಇಸ್ ಶಿಫ್ಟೆಡ್ ಟು ದಿ ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ವಿ ಆರ್ ಆಲ್ರೆಡಿ ಅಬ್ಸಾಲ್ವ್ ಫ್ರಮ್ ದಿ ಲೈಬಿಲಿಟಿ, Miraj. The tribunal itself examined and produced the documents.
ಅವರ ಕ್ಲೈಮೇಟ್ ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ.
On 20th of February 2008, an accident occurred in which the pillion rider Vijay Kumar suffered grievous injuries and was killed. As a consequence, his parents preferred a claim petition, and by the impugned award, the tribunal as case of death.
Yes.
ಮತ್ತೆ ಬರೀ 2,16,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
40,163 ಹಾಕಿದ್ದಾರೆ. ಅವರು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ.
2,69,000.
ಅವ್ರ ನೋಟಿಸ್ ಗೊತ್ತಿದೆ ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಓನರ್ ಅಂತ ಮೋಸ್ಟ್ಲಿ ಅವ್ರಿಬ್ರು ರಿಲೇಟಿವ್ಸ್ ಇರ್ಬೇಕು, ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಅವರು ಹಾಕಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ
This appeal is by Abdul Hamid, who had been arraigned as the third respondent before the tribunal. He contends that he had sold the motorcycle on 20th of, when was the date? 29/10/2007. That is about 4 months prior to the accident. And the registration was also changed in the name of the fourth respondent, J.N. Gautam. He submits that only because the certificate of insurance was still standing in the name of the appellant. The tribunal has made him liable. Since the motor vehicle was covered only with the statutory policy and the risk of the pillion rider was not covered under the policy. Next part. It cannot be in dispute that the moment a motor vehicle is transferred, the certificate of insurance that has been issued in favor of the registered owner will also stand transferred in the name of the purchaser. In the view of the matter, the liability fastened on the appellant on the ground that the insurance policy stood in his name cannot be sustained. The impudent award insofar as it relates to fastening liability on the appellant is set aside. And it is held that the fourth respondent, who was the registered owner as on 22/2008, would be liable for satisfying the award passed by the tribunal. The appeal is accordingly allowed. Amount, if any, in deposit made by the appellant shall stand refunded to him.
ಕಂಪನಿ
Delay ಕಂಡು.
ಕಂಪನಿ ಮೇಲೆ ಕಂಪನಿ ಮೇಲೆ
ನಿಮ್ಮೇಲೆ ಏನಿಲ್ವಲ್ಲ, ಬರೀ ಅವ್ರ ಮೇಲೆ ಮಾಡಿದ್ರು.
Number 15, Vivekanand Gupta.
Beneficiaries privilege as a proposed petitioner by order 82/2024.
Yes. Ashuram.
Memo along with affidavit dated. What is it posted for today?
I have filed the IAML. This case, the IAML will not be. All of the following, the various beneficiaries who are outside Bangalore and abroad are expected in the next 4 or 5 days. I haven't filed before the 6th of December. All the power of attorney.
You are required to file the power of attorney, isn't it?
Yes. They are expected in the next 2 to 3 days. 8 of them are. 8 beneficiaries.
Read list.
Sixth December. 6th December. Number 16, Yes Nagraj.
Kindly call this on Monday, my lord. I have received, my lord, Sago licit, my lord. I will produce it, my lord, where.
ಏನಾದ್ರು the finding is wrong ತಾನೆ.
ಅಲ್ಲಲ್ಲ ಅದು ಅವರು ending is my lord, it is not related to me, that person is not at all related to
My
me.
order is wrong.
ಅಲ್ಲ ಅದನ್ನ ನೀವು ಅದನ್ನ ಬಗ್ಗೆ ಏನು ಬರ್ದಿಲ್ಲ ತಾವು.
ಬರ್ದಿದ್ದೀನಿ
ಇಲ್ಲ
ನೋಡಿ.
ಇಲ್ಲ my lord, kindly see para 6. Para 6 of the order,
3 ನೋಡಿ. The
as
petition-
stated above, entry in favor of Asifuddillah is my father, correct? Was not in dispute, and 2 sons claiming to be in unauthorized occupation had challenged the said entry, that is petitioner, Euro.
ಇಲ್ರಿ, see para 3, the petitioner,
Para number 3.
para 3,
Para 3 ನಲ್ಲಿ.
the petitioner, the son of Asifudullah being.
Yes, my lord.
This is
No, no,
wrong.
the petitioner, the son of Asifuddillah, correct, my lord.
ಆಮೇಲೆ the deputy
Being
commissioner-
agreed by preferred revision before the deputy commissioner after taking note of the fact that the revenue entries did not stand in the name of the petitioner's father.
did stand in the name of the petitioner's father. This is wrong.
ತಪ್ಪದು, that is, I'm not, it is in fact, it is not in favor of the ನಮ್ಮ ಹತ್ರ ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದಾವೆ.
ಈ ಆರ್ಡರ್ ತಪ್ಪಾಗುತ್ತಲ್ಲ.
ಅಲ್ಲ,
I
ಅದು-
proceed on the
ಹಂಗ
footing.
ಅಲ್ಲ, ಅದು ಏನ್ ಹೇಳಿದ್ ತಾವು ಒಂದ್ ನಿಮಿಷ ಓದ್ತೀನಿ ನೋಡಿ. Name of the petitioner's father and the same was changed in the name of the petitioner's mother. Actually, my lord, it was in the name of Asifuddillah. Asifuddillah was,
The order of the deputy commissioner is not to that effect. The order of the deputy commissioner is that the entry stood in the name of some, or a
ಇಲ್ಲ ಅದನ್ನು ಇಲ್ಲ, ಅದು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ
Amir Abibullah. The finding of the deputy commissioner was that the RTC was standing in the name of Amir Abibullah. I proceed on the footing that was standing in his name, in his father's name. Therefore, you cannot have any grief.
ಒಂದ್ ನಿಮಿಷ ತಾವು ಹೇಳ್ತೀನಿ. ಒಂದ್ ನಿಮಿಷ ತಡ್ರಿ ಸರ್. ಅಮೀರ ಹಬೀಬುಲ್ಲಾ ಖಾನ್ ಎಂಬ ಹೆಸರು ರಿವಿಷನ್ ಅರ್ಜಿದಾರರ ತಂದೆ ಆಗಿಲ್ಲ. ಅವ್ರ ಹೆಸರು ಇದೆ ಅಂತ ಇಲ್ಲ ಹಿಂದ್ಗಡೆ.
I proceed on the
ಗುತ್ತಿಗೆ
footing.
ಸಾಗುವಳಿ ಚೀಟಿ ಪ್ರತಿಯಲ್ಲಿ ಅಲ್ಲಿ ಮಿಲಾಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
He proceeded on the footing that revenue entry stood in the name of his father. That is incorrect.
No, there are, my lord, kindly see, my lord, this, my lord, survey number 15/7, 15/8. There are other, my lord, entries, my lord, in respect of survey number 15/4 and 15/5. ಆ ಪ್ರೊಸೀಡಿಂಗ್ಸು ಇದಾವೆ. ಅದಕ್ಕೋಸ್ಕರ ನಮ್ಮ ಹತ್ರ ಸಾಗುವಳಿ ಚೀಟಿ ಇದೆ, ಅದನ್ನ ತಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ. ದಟ್ಟೆ ಮತ್ತೇನಿಲ್ಲ. ಅಂಡ್ ಮೋರ್, my lord, ಇದು as your lordship yesterday, ಅಲ್ಲ ನಿಮಗೇನಂತ ಅಲ್ಲ, ನಿಮಗೆ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ.
ಮಾಡಂಗಿದ್ರೆ ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಇಲ್ಲ ಮಂಡೇ ಮಾಡಿ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳುದು
ಅವ್ರ ಜೊತೆ ಮಾಡ್ಬಿಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್, ನನ್ನ ಜೊತೆ.
it is not a public interest litigation, we cannot argue.
Okay.
25th, seal number 17, to Sachin BS.
That respondent number 4A is said to be deceased, my lord. So I have filed a memo stating them to bring their legal haste on the records, man, because I could not trace their
What is the memo that you have filed?
stating to bring their legal haste. Memo dated 7/8/2024.
The application was allowed.
Yes, ma'am.
Was the application allowed?
Yes, ma'am. Application was allowed, ma'am,
When?
by the
This one.
(28/8/2023). They filed a memo.
Nobody appears for the LRs.
4C and E.
On the death of R4, applications were made to bring his LRs on record, that is from 4A to 4F. The registry has made a note that R4, B2, E have been served. And R4F is also represented by Vishruti Sina. It is also
Bappa
noticed that
Vishruti.
R4A was the wife of the deceased. Since our children are already on record, the question of taking further steps to bring the LRs of R4A would not survive. Stop. Since the right to sue survives on R4B2F, it might be necessary to allow the applications filed to condone the delay in setting aside the abatement, comma, to set aside the abatement and to bring the laws on record. Cost rate to be amended. Amend the cost rate.
Petition copy on putting. I don't have the whole one. Today it's a petition copy.
Number 18.
Yes, amendment is not carried out.
Carried out, my lord. Amendment last date ಅಲ್ಲಿ carry out ಮಾಡಿದೀವಿ.
It stated that cost rate has been amended.
Amendment last carry out ಮಾಡಿದೀವಿ sir last date ಅಲ್ಲೇನೆ. Kindly, we are ready in the matter, kindly pass it.
List.
29th. 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 Number 19, Shri Shanmukha.
I prefer week's time to carry out amendment.
Weeks time.
Till number 20. Shri Kalleshappa case.
Already taken steps, please, my lord. On
Ninth respondent.
19/11/2024 itself, taken steps. R10.
Who's R7?
R7 is not claimed, please. R7 is not claimed ಅಂತ ಬಂದಿದೆ.
ಯಾರು ಅವರು ಅಂತ?
ಅವರು
ನೀವ್ ಯಾರು ಪರ್ಚೇಸರ್ ಗ್ರಾಂಟಿನ?
ನಾವು ಗ್ರಾಂಟೀಸ್.
R7 ಯಾರು?
One of the grantees one, please.
Who's R7 and R10?
Purchaser, please.
Does he have any subsisting interest?
He has sold it. He
To
doesn't
whom?
have, he doesn't have any subsisting interest.
To whom has,
Parties before the.
right, but to whom has he sold it?
He has sold it to Krishna.
ಅವ್ರ rank ಹೇಳಿದ್ರು.
Rajesh.
Now you appear for Krishnappa. Who's,
Krishna is fifth respondent in 20.5.
he is represented by M.R. Narayan in that case, isn't it?
In 20.1.
No, in 20, R10 is Krishnappa.
Please do.
Correct. This Krishnappa, is he the same fifth respondent in your petition? Please notice that 10th respondent in WP 23904/2021 is the fifth respondent in WP 1468/2022 and is represented by Shri M.R. Narayan. Therefore, M.R. Narayan is directed to accept notice for R10. Now, what about this R7? R7 is the Papu.
He is respondent number 12. My petition.
12.
12 in my petition.
12 ಸರ್ವಾಗಿದ್ರೆ ಇಲ್ವಾ ನಿಮ್ರಲ್ಲಿ?
No, he is reported to be dead. I filed a memo that respondent number 10 and 11 are his brothers. Since they are already on record,
It is notice that R7 in WP 23904/2021 is respond number 12, correct?
Yes.
In WP 1468/22 and he is reported to be dead. A memo is also filed to the effect that R10 and R11 in WP 1468/2022 are his LRs and there is no need to take further steps. In WP 23904, R5 and R6, correct? R5 and R6 in this writ petition are his LRs. Others are
yes, my lord, yeah.
R5 and R6 would consequently be the LRs of R7. Hence, necessary note be made that R5 and R6 are the LRs of R7. So consequently, no steps need be taken in respect of R7. 20.1 ನಲ್ಲಿ the application filed to bring the LRs of notice ಹೋಗಿದೆಯಾ?
No.
Issue notice on IA 2 and 3 of 2024. ಈ ಕೇಸಲ್ಲಿ if R6 is dead in this case, who are they? In the petition filed by him, R6 here. ನಿಮ್ ಕೇಸಲ್ಲಿ R6 ಯಾರು? What's his name?
ಆರ್ಸಿಸ್ ಮಂಗಮ್ಮ
ಮಾಡೇ ಇಲ್ವಾ?
ಇನ್ನು ಅವ್ರ ಪಿಟಿಷನ್ ನಾವು ಮಾಡಿದ್ವಿ.
ಮಾಡಿ, ನೀವು ಮಾಡಿ ಅವ್ರನ್ನ.
1468. 1468.
Number 21, Shri K.R. Krishnamurthy.
Notice issued to R7, my lords, it reflects that is refused.
Who's R27? R7 or 27?
27, ಇಲ್ಲ, 7. Only 7 respondents are there.
Yeah, refuse ಅಂತ ಹೇಳಿ.
Filed an application for impleading
endorsement. That R7 is refused notice. Notice to R7 is held sufficient.
That's my application.
And summons ಏನು?
Hand summons, my lords, I had taken hand summons against respondent number 7. And he served, my lords.
In view of the refusal of the notice by R7, it would not be necessary to issue and summons to R7.
That's application IA number 2/23. This was the notice on IA number 2, my lords.
27 ಇಲ್ಲ ಅಂತಾರೆ, ಬರೀ 7 ಅಂತಾರೆ. 27 ಅಲ್ವಾ ಗ್ಯಾರಂಟಿ?
27 refused.
7.
Only 7 respondents. Uncle.
Only 7 respondents.
Serial number 21.
It's proposed respondent, my lords.
What is the
Impleading-
application that is pending?
2 of 23, that may be allowed, my lords, on which the notice was issued.
Who is R7?
R7 is the purchaser, subsequent purchaser, my lords.
Since it is stated that R7 is the subsequent purchaser, the application filed for impleading is allowed postulated to be amended.
And there is one more application, my lords, IA number 3 of 23, wherein I have sought direction against respondent number 7. And also, my lords, on the last occasion, I had filed a memo along with photographs to show that, my lords, there is a construction taking place. And I have filed the police complaint as well.
And
Kindly
here, my
see
lord,
the memo, my
sale
lord.
has taken place after
You
the
are
act.
asking for alienating or encumbering the petition.
Please, earlier I had filed an application, my lord. Subsequently, my lords, on 15th July 2024, I have filed a memo.
The prayer is only not to encumber.
Please, my
And
lords,
the
in the,
prayer-
in the earlier application 2023, in the year 2023, along with the application for impleading, I had filed this application. It was pending for consideration. Now, my lords, subsequently, he has started putting up the construction. That photographs, my lords, may,
What is the case about?
my lords, I am for the grantee, my lords. It was granted in the year 1982.
T2.
82. The petitioner is the wife of the original grantee.
When was it sold?
Well, that's 1996,
And when was the application resumption made?
2001,
No, 2007.
2005 and 6, my lords. 2005.
Why was it rejected? Why was the resumption application rejected?
My lords, before the assistant commissioner, my lords, they said, my lords, one date, the document, the first alienation, my lords, was on 16/11/1996. The document came to be executed on 16/11/1996. Subsequently, my lords, it was registered on 9/3/1998. In between, my lords, 17/12/1997, permission was accorded.
Then
Now, our contention was that, my lords, the documents comes to, I have produced one,
before the sale deed is registered, they have secured permission.
no, my lords, after the execution of the document, my lords,
See, so, but before, until it is registered, there is no conveyance.
my lords, that I have countered. My lords, the kindly see page number 43. Where before the deputy commissioner, my lord, special deputy commissioner, I had produced one. I relied on a citation.
The sub-registrar probably did not register it because there was no permission. He kept it pending registration. On getting permission, he has registered it.
However, my lords, it says the documents comes to existence on the date of it is executed, not from
The
the date of.
document has come into existence, but the alienation is complete only when it is registered. And as on the date of the registration, there was permission.
My lords, earlier, my lords, it was allowed before the deputy commissioner. Deputy commissioner upholded my contention that it comes to existence only after registration. Then, my lords, respondent number 6, my lords, filed a petition before this honorable court stating that she was not made a party. Then, my lords, it was remanded back. In the remand, my lords, I did not contest. Because, my lords, PTCL number earlier, it had numbered as 48 bar
Whether you
2007.
contest or not, the fact remains that there is permission accorded prior to the registration of the sale deed.
Prior to
Then
registration.
how can you invoke 4(2)? How can you invoke section 4?
Let's subsequently, special deputy commissioner also goes on a fact that well, he did not consider my case that it was not registered.
By the facts that you narrated, once there is permission, the alienation becomes valid. You can't invoke PTCL Act.
Still, my case is that, my lords, there was no notice issued on me, my lords.
For what?
When it was remanded, my lords, there was no notice. I would have contested before the deputy commissioner.
You want me to close it? I'll close it now.
I'll take instructions then, my lords.
List. 29. 29. Number 22, Shri Ravi Kumar Bia.
Memo, 22.1, my lord,
In 22, we are withdrawing the case
as requested.
in accordance with the memo.
Writ petition is dismissed as withdrawn. Withdrawn memo hakidra?
In 22, my lordship, memo for withdrawal we have filed.
What about the other one, 22.1? No, 22.1, my lord, my name is shown as appearing for the impleading applicant. Lord, I have returned the brief to the party, filing a retirement memo, my lord. The Ashwin Kumar memo stating that he had returned the brief to the proposed impleading applicant respondents. And he also files a memo enclosing a copy of the acknowledgement of the applicants for taken back the file. Ashwin Kumar is therefore permitted to retire on behalf of the impleading applicants in IA 1/2022. Who's for the petitioner here?
We are not
Ganesh
a party.
Kumar.
The list. What do you want?
So, sorry, I didn't hear, my lordship.
No, I dismiss your petition as
Much
withdrawn.
obliged, much obliged.
Number 23, Shri Jaikirti MC.
For the petition. Permitted to file the amended petition.
The matter, no?
Well, in this matter, the respondents claim to the legal heirs of the sole of plaintiff.
You are for defend number 2. What is the impugned order?
Impugned order is the order passed on the application filed by the respondents claiming to the legal heirs of the deceased plaintiff. In the application filed by them, they do not narrate the relationship. They say that the deceased was their grandmother.
Grandmother.
That's the
Where is the
statement
application?
government made in the affidavit, Manoj.
Where is the application?
Please, Manoj, produce it.
What is the suit?
Annexure C, suit for declaration,
Declaration that
declaration injunction.
Putterema was the owner of the property.
That's what she claims. She claims through the sale deed dated 1978, 98.
Early the application
Applicant annexure C, Manoj.
Annexure C.
Please, Manoj. In page 30, 32 is the affidavit. The plaintiff, para 2 of the affidavit, about 6 lines from the Top. The plaintiff have no issues. We are the sole legal heir of my deceased grandmother. Except ourselves, there are no other legal heirs to my grandmother.
ಏನ್ರಿ
My lord, suit for declaration injunction, my lord. My lord, the plaintiff husband has acquired property. And later on, my lord, expired, pass away, my lord. The plaintiff,
if the plaintiff had no issues,
yes,
how can she be the grandmother of somebody?
my lord, this plaintiff's husband's heirs. As per Hindu Succession Act, my lord, when there is no issue for the female.
Grandmother ಅಂತ ಹೆಂಗ್ ಆಗ್ತಾರೆ ಅವರು?
My lord, not only grandmother,
ಏನ್ ಸಂಬಂಧ ಅವ್ರ ಯಜಮಾನ್ರಿಗೆ ಏನ್ ಸಂಬಂಧ ನೀವು?
ಯಜಮಾನರಿಗೆ ನಾವು ಅಣ್ಣನ ಮಕ್ಕಳು, ಮೊಮ್ಮಕ್ಕಳು ಎಲ್ಲ ಯಾರ್ಯಾರು ಬದುಕಿದಾರೋ ಅವ್ರೆಲ್ಲಾರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿಕೊಂಡು ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಅಪ್ಲಿಕೇಶನ್.
ಆ ರೀತಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಆಯ್ತು ಹೇಳ್ತಿದಾರಲ್ಲ ಈಗ. The petition is filed challenging an order by which an application to bring the legal representatives of the deceased plaintiff has been allowed. It is a contention of the petitioner that the affidavit filed in support of the application did not indicate the relationship between the deceased plaintiff and the applicants, and it merely stated that she was the grandmother of the applicants. Its learned counsel appearing for the
Respondents.
legal representatives of the deceased plaintiff submits that the deceased plaintiff and her husband had no issues, and the applicants are none other than the children of the deceased plaintiff's brother-in-law. That is the brother of the deceased. That is the brother of the deceased husband. In my view, since the applicants claim to be the legal heirs of Putirama's husband, they would be entitled to prosecute the suit on behalf of Putirama. There is no error in the impugned order, and consequently the petition is dismissed.
On one submission, no? In respect of the similar matter, Supreme Court has laid on the law that merely coming on record will not determine their rights. They'll have to establish their rights independently. No? Paragraph 12 of the
I'm only saying
judgment.
that to safeguard the estate, they are
Please.
coming.
Only to that extent.
That's what I said.
That's all.
Number 24, Sri Loitashwa Manaka.
Last occasion itself, I have tried amended the petition.
ಹಾಕಿದಾರ?
ಹಾಕ್ತಿದ್ದೀನಿ ಇವತ್ತು ಮಾಡಿದ್ದೀನಿ.
Amended petition has been filed. File ಮಾಡಿದ್ರಾ?
Last, this is covered by judgment of Supreme Court. Let's TK Manjunath. As well as this land has been granted on upset price.
Ready na?
I will, no, next week.
List.
29. Number 25, Sri Nayak.
Dismissal against R5. Who's R5?
R5 is the earlier purchaser, my lord.
ನೀವು ಯಾರು ಗ್ರಾಂಟಿಗ?
I'm part the purchaser, my lord. Petition is the purchaser, my lord.
ಏನ್ ಕಾಂಪ್ರಮೈಸ್?
Compromise, my lord, the respondent upon, my lord, the legal heirs of the original grantee, my lord. The property was granted, my lord, 29/11/1962, my lord. The Ramanayaka, son of Lale Naika. After death of original grantee, my lord, the son of the original grantee sold the property in favor of the fifth respondent, my lord. The fifth respondent, my lord, sold the property in favor of the Anmanayaka. Anmanayaka sold the property in favor of the petitioner, my lord. The compromise petition, my lord, the original grantee and the subsequent petitioner filed the compromise petition, my lord. Property, the grant was property was 4 acres, 35 gundas, my lord. The original grantee was the son of
ಏನದು ರಾಜಿ ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
2 ಎಕರೆ ಅವ್ರಿಗೆ 2 ಎಕರೆ 30 ಗುಂಟೆ ಇವ್ರಿಗೆ ಅಂತ ಮಾಡ್ತಾರೆ. Total 4 acres, 35 gundas, my lord. 2 acres sold property in favor of the.
Total ella they can, my lord. This is under PTCL and sale has taken place and.
No, if the grantee were to withdraw the application for resumption,
House.
that is one thing. ನೀವು ರೆಸಂಪ್ಷನ್ ಮಾಡಬೇಕು.
And 84 was the sale, my lord. Even so much can't be prohibited.
25/7/1984, my lord, sold the property, my lord, in favor of the,
If the application is withdrawn,
yes, my lord.
I can set straight the orders and dismiss the. ಅದ್ ಬಿಟ್ರೆ I can't ಭಾಗ ಮಾಡೋದು ಹೆಂಗಾಗುತ್ತೆ?
Even, my lord, even before court, a compromise petition and all, it can't be entertained, my lord.
If she wants to withdraw the entire application that she has filed for resumption, that is one thing. Do it and then probably get a sale it from him for the 2 acres. As things stand, I can't in proceeding. ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, my lord. 84 ಅಲ್ಲಿ ಸೇಲ್ ಬೇರೆ ಆಗಿದೆ. ಈಗ ಸೇಲ್ ಇಟ್ ಮಾಡಿದ್ರು it is in completely violation, my lord. Permission ತಗೊಂಡೇ ಮಾಡಿ.
ವಾಪಸ್ ಅವ್ರಿಗೆ 2 ಎಕರೆ ಕೊಡ್ತಾರ.
2 ಎಕರೆ, ಟೋಟಲ್ 4 ಎಕರೆ 35 ಗುಂಟೆಸ್, my lord, granted, my lord. 2 acres sold the property in favor of the grantee, my lord.
Compromise ಆಗಲ್ಲ. I can't give seal of approval. If she wants, let her withdraw the entire application for resumption. Then maybe either go to the government, get approval to purchase or do anything else. But once is an order of resumption, I can't satisfy the order of resumption.
Time ತಗೊಂಡು ನಿಧಾನಕ್ಕೆ next week ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಯಾವತ್ತು application ಆಗಿ resumption ಗೆ?
2006, 27/7/2006, my lord.
2009 and 10, my lord.
So 16-25 years. Dikshit Sahibar order, it put, shall I set aside the orders? But then again, they'll be at their mercy.
Let them decide and come next week, my lord.
ಯೋಚನೆ ಮಾಡಿ.
In respect of my humble request, my lord,
ಹೇಳಿ ನಾಯಕ್ರೆ.
in respect of 2 acres, we have no objection because already 2 acres.
How can I permit that?
Allah, purchaser, because purchaser, they have come forward
Can the
to settle
purchase
the
be
issue,
good in,
my lord, because it should not be continued forever. So
Can the
therefore, I
purchase-
want to settle with this.
like can I say the purchase is good in half, good in bad in half?
Allah, half already we have taken position, my lord. Remaining portion, my lord, it is with the purchaser. Therefore, we are confirming, my lord, by way of compromise.
ವಿಡ್ರಾ
my lord.
ಮಾಡ್ಕೊಂಬಿಡಿ. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ರಿಸಂಪ್ಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಬಿಡಿ. ಆಮೇಲೆ ಕ್ರಯಪತ್ರ ಬರ್ಸ್ಕೊಡಿ.
ಅಷ್ಟು
ಅವಾಗ 4
permission
ಎಕರೆ
ಕೊಟ್ರು
ವಾಪಸ್
ಸಾಕು ಸ್ವಾಮಿ. ಅಷ್ಟು permission ಕೊಟ್ರು ಸಾಕು.
ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀರಾ?
ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀನಿ ಮತ್ತೆ ಇನ್ನೇನು.
ಆಮೇಲೆ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅದಕ್ಕೋಸ್ಕರ some amount they have paid, therefore we want to settle the issue, my lord. Allah, instead of compensation, now we are entitled for compensation from the government. That going to payable by them. ಅದಕ್ಕೋಸ್ಕರ.
Advice is granted to withdraw the application, thereafter do whatever you want to do.
Please, my lord, definitely.
ಇಲ್ಲಾಂದ್ರೆ ಆಗಲ್ಲ, ನಿಮ್ ಪ್ರಕಾರ ಆಗಲ್ಲ.
ಆಯ್ತು ಸ್ವಾಮಿ. Time may be granted.
29. Number 26, Shar Shashidhara.
Sir, the awaiting service, in the connected case, NR Nayak is already appeared. I have taken steps.
ನೋಡಿ ಅಲ್ಲೇ ಇದಾರೆ ಕೇಳಿ.
ನೋಟಿಸ್ ಹೋಗಿದೆ. ಕನೆಕ್ಟೆಡ್ ಕೇಸ್
ಮಾಡ್ಲಿ ಯಾರಿದ್ದಾರೆ?
ಗೆ ಇವರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ ಆಲ್ರೆಡಿ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್.
Since it is stated that Shri NR Nayak has entered appearance on behalf of R3 to R11 in WP number. ಇದೆಯಾ ನಂಬರ್ ಇದೆಯಾ?
ಇದೆ.
WP number so and so. He is ready to take notice for R3 to R11 in this writ petition also.
WP 10360 is already disposed of matter, Manoj. WP is already disposed of.
ಅಲ್ಲ, ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೋತೀನಿ, ನಮಗೂ ಒಂದ್ ಸ್ವಲ್ಪ ಫೀಸ್ ಬರ್ಲಿರಿ. ಏನ್ ನೀವು?
ಅದಕ್ಕೆ ನಾನು ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ನೀವು ತಗೊಳ್ತೀನಿ. Office to print his name in the first list. ಜಾಸ್ತಿ ಆಗಿ ಹೋಗಿದೆ ಫೀಸ್, ನಿಮ್ ಕಮ್ಮಿ ಆದ್ರೆ ಒಳ್ಳೇದು.
ಹಂಗೇನಿಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ, ಅವರು ಸಡನ್ ಆಗಿ ತಗೊಂಡು
ಇಯರ್ ತಗೊಳ್ಳಿ. ಡಿಸ್ಪೋಸ್ ಆಗಿ ಹೋಗಿದೆ.
27, Shri Timmegowda.
For petitioner in this matter, my lordship, there are 4 minor office objections are there. Last time confusion agi nanu document remove ಮಾಡಿದಾಗ seals ಹಾಕಿಲ್ಲ. I will do the needful today itself, my lord.
Weeks time is granted to the need.
Date may be fixed, my lord.
Realist.
29. Number 28, PSV Prakash.
In office objection,
Purchaser's petition. My lord, there is a delay of 39 years. I have challenged, my lord, the constitutional validity of section 5(1).
Then as per annexary order number, what is your?
No, they have what, they have impleaded, my lord, page 26, annexure A, page 26, that is the, my lord, cast title. T.S. Veerbhadraya, father of the petitioner, he was made a party, he died, my lord, on 22nd May 1997. And Bhadraya also, my lord, died, and he was made party.
Who's Bhadraya?
Bhadraya, I think he must have purchased the remaining 5 acre is the total extent. I purchased.
Party ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ ಅವರು ನಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ 2 ಎಕರೆ. Subject matter is only 2 acres.
Objection is annexure to be stated with respect to sale dated 6/1/65 and to be filed along with WD.
65 is my sale deed in respect of 2 acres.
ಆ ಕಾಪಿ ಕೊಡು ಅಂತ ಅಂತಾರೆ ಅವರು.
ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕೊಡಲ್ವಾ?
ಸೇಲ್ ಡೀಡ್ ಈಗ ಆರ್ಡರ್ ಆಗಿದೆ, ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿರೋದು. That sale deed is held to be null and void.
No, the office wants a sale deed. You don't want to give the.
No, I can furnish.
Then as per annexure A, order dated 13/12/98 of Tahsildar Tumkur to be filed. That is the second office objection.
So there, Veerbhadraya is the person.
What is this 13/12/98, 1938 order?
ಅದು ಗ್ರಾಂಟ್ ಆಗಿರೋದು. ಪ್ರೇಯರ್ ಅಲ್ಲಿ the mistake I have made is prayer. Your lordship and see prayer. Lord, that is 30 is the, my lord, the date of grant according to them.
34 ಹೇಳ್ತಾರೆ. ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಡೇಟ್ ಆಫ್ ಗ್ರಾಂಟ್ ಇಸ್ 34.
ಅದಲ್ಲ ಏನು annexure A and B are the orders.
5/12/1934 was the grant.
Grant order. Annexure prayer B, your lordship and is. Prayer B.
Objection deferred for the present.
My prayer B, my lord, page 23, my lord, what I said is I only described what is the nature of the order passed by the Assistant Commissioner. Therefore, they wanted me to produce 6/1/1965 sale.
ಅದಕ್ಕೆ prayer simple ಆಗಿ ಇಟ್ಕೋಬೇಕು.
That
ನೀವು
is the-
ಕಾಂಪ್ಲಿಕೇಟ್ ಮಾಡಿದ್ರೆ ಆಫೀಸ್ ಅವ್ರಿಗೆ ಕನ್ಫ್ಯೂಸ್ ಆಗ್ಬಿಡುತ್ತೆ. Issue notice. HCGP accepts notice for R1 to R3. This will interim stay. I sought for post along with.
Will stay, my lord.
Allow.
Number 29.
Week stay. ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
Number 30, Shri Nagaraj Hegde.
No objections, my lord. I have only challenged, my lord, the endorsement issued by the respondent number 1. Lord, wherein, my lord, I have sought for restoration of the.
ಆರ್ objection ಇದೆ, 5 objection ಇದೆ.
Typed copy ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮೇಜರ್ objection ಇರೋದು ಅದೊಂದೇ ಸರ್.
ಯಾವ್ದೋ ಇದು ಮಾಡಿಲ್ಲ. Annexures to be attested by competent authority.
That is annexure seal ಹಾಕಿಲ್ಲ. ಎಲ್ಲ ಮಾಡಿಸಿ.
ಮಾಡ್ಬಿಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ತೀನಿ.
ಆಯ್ತು.
Week same is granted under the office objection. Release on
29, watch out. For hearing on IS, number 31.
IAS IA is filed some clerical error is there in the order, main order.
ಏನ್ error? Instead of his brother ಅಂತ ಬೇರೆ ಏನ್ ಹೇಳ್ಬೇಕು?
ಬೇರೆ ಏನಿಲ್ಲ, ಬ್ರದರ್ ಬದಲು ಮ್ಯಾಟರ್ನಲ್ ಅಂಕಲ್ ಆಗ್ಬೇಕಷ್ಟೇ.
An application file stating that there is an error in para 4, 5, 6 and 7 in which first respondent is referred to as the brother of petitioner.
ಮ್ಯಾಟರ್ನಲ್ ಅಂಕಲ್ ಪಿಟಿಷನರ್.
It is stated that the
ಅಜಿತ್ ಪ್ರಸಾದ್ ರೈ.
it is submitted that as a matter of fact, it was not the petitioner's brother, but his maternal uncle, which was to be incorporated in para 4, 5, 6 and 7. In view of the above, in para 4, 5, 6 and 7 of the order, wherever the term brother of the petitioner is referred to, shall be read as maternal uncle of the brother. Application.
Number 32, Shri A. Ravishankar.
Delay condoned. Next week,
Monday. Number 33, Shri Prithvi Vadia.
Respondent number 4, my lord.
for amendment, eh?
Amendment, original order, by mistake, original order was not challenged. That I have, now by way of amendment, I have challenged that order.
The application for amendment is allowed since it not cause any prejudice to the respondents. Who's R4C?
R4C is the LR of original, that is original grantee, that is son of original grantee. In respect of R4 A, B, D, E, they are served, but they are not.
Since R4 A, B, D,
Well, one kind
R4
submission.
A, B, D and E are already served and have remained unrepresented. Notice to R4C would be unnecessary.
My learned friend is appearing.
For respondent, LRs of respondent 4, my lord. But in this case, my lord, earlier occasion, the assistant commissioner.
ವಕಾಲತ್
was-
ಹಾಕ್ತೀರಾ?
ಹಾಕ್ತೀವಿ. ಇದರಲ್ಲಿ ಅಲ್ಲ, ಇದು ಪಿಟಿಷನ್ ಮೇಂಟೈನಬಲ್ ಆಗ್ತಾ ಇಲ್ಲ ಇವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರಕಾರ, ಬಿಕಾಸ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಪಿಟಿಷನರ್ ಸೀಕಿಂಗ್ ಪರ್ಮಿಷನ್ ಟು ಚಾಲೆಂಜ್ ದಿ ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ಮೇಲೆ. ಇವರು ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ನ ಡಿಸಿ ಮುಂದೆ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಇನಿಷಿಯಲಿ 1986 ದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ಆನ್ ಆರ್ಡರ್.
Purchaser
I am the purchaser. This is not the proceedings. which were-
86 ನಲ್ಲಿ ಆಗೋಗಿದ್ದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
This is not the proceedings initiated under section 5 of the PTCL Act, Your Lordship. I had preferred an appeal before the Assistant Commissioner under section 136(2), an appeal was preferred, challenging the mutation register made in favor of respondent number 4. That appeal came to be remanded to the to Tashildar on the premise that Tashildar has passed a mutation order without impleading, without issuing notice to the petitioner's hearing. Since I was the purchaser of this property and mutation was entered in my name, that was not set aside by the, in spite of setting aside that, and the Tashildar has entered the name of respondent number 4 in a separate mutation proceedings. The Assistant Commissioner remands that matter to the Tashildar. Tashildar, after remand, Tashildar invokes the provision of the PTCL Act and he holds that this is, there is violation of the PTCL Act, and he recommends the Assistant Commissioner to cancel the, to set aside the sale deed. Pursuant to that recommendation made by the Tashildar, the Assistant Commissioner, there is no suo motu power or anything like that. The Assistant Commissioner set aside the sale deed and he forfeits the land by invoking the section 5 of the PTCL Act. I preferred appeal before Deputy Commissioner. I brought to the knowledge of the notice to the Deputy Commissioner that this was not the proceedings initiated either by the grantee or by the purchaser under the PTCL Act. whereas I had preferred an appeal under section 136(2), challenging the mutation register. But now in my proceedings, in my appeal, the Assistant Commissioner has passed this order, but the Deputy Commissioner without.
It was open to the Deputy Commissioner to inform the Assistant Commissioner that there's an alienation made in contravention of terms of the grant, therefore initiate proceedings.
It was open. It was open. On that, the Assistant Commissioner could have initiated suo motu proceedings as contemplated under section.
Sir, has passed an order of resumption, isn't it?
He has passed an order, but not on by exercising the power suo motu.
If
In
somebody,
my appeal,
if somebody brings to his notice,
Your Lordship's kindly, suo motu proceedings has to be initiated by the Assistant
136
Commissioner
proceeding.
independently.
136 proceeding is converted into resumption proceedings.
No, he cannot, because that was my appeal, Your Lordship. Suppose if it was an appeal filed by the grantee, then
Like merit million case ilva?
merit ಮೇಲೆ delay ಮೇಲೆ ಇದೆ. Even for a moment, if you assume that the Assistant Commissioner has initiated suo motu proceedings, that proceedings has been initiated after lapse of 11 years.
Kindly come to the page number 20. One page alle.
ಯಾವಾಗ ಆಗಿದ್ದು?
First sale 1997.
After the act came into force. When was the grant?
Grant the 1961. ಇಲ್ಲಿ ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ 1960.
Fifth ಹಾಕೊಳ್ಳ ಮೇಡಮ್ ಇದನ್ನ fifth ಹಾಕೊಳ್ತೀನಿ.
Please, madam.
That is the period of non-alienation was over after the act came into force.
87, 88 ಅಲ್ಲಿ Assistant Commissioner set aside ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ ಸೇಲ್ನ.
Within time, they have filed the application, my lord, for a resumption. And 98, my lord, the Assistant Commissioner.
He said 61 is the grant.
No, my lord, that is, my lord, facts here, my lord, page.
61 is the grant. Your Lordship, here there is a peculiar case. 61 was the grant. The father of the petitioner herein has purchased this property. There are two sale deeds. This property under a sale deed dated in the year 1964 from the very same respondent herein. Pursuant to that sale deed, the father of the respondent number 4 files an application before the Assistant Commissioner for resumption of land. That came to be allowed by the Assistant Commissioner by order dated 8/9/1988. Thereafter, the petitioner hearing has purchased the very same land under another sale date from the respondent number 4 hearing in the year 1997.
So after resumption, you purchased it once again.
Once again,
Again without permission.
without permission. Thereafter mutation was in.
I have done the fifth.
Yes.
I have a doubt, after resumption, will that term stand extended or fresh term? ಹೆಂಗಾಗತ್ತೆ?
Yes, I'll.
The land is resumed.
See, it is, my lord, within time, they have filed the application, my lord,
No,
immediately.
what he's saying is the land was resumed.
Yes.
After the resumption, he purchased the land once again.
Yes, my lord.
Without
that is
permission
prior
or-
Prior permission is must, my lord, is my.
No, but if the term of non-alienation is over by then, 61 is the grant.
And after the completion of terms, my lord, they have to seek the
5th
permission.
December.
Amendment, Your Lordships, that was allowed, so that would.
Yes. ಇಲ್ಲ one. Steps. You will take notice?
Yes, madam.
Naglinga accepts notice for the LRs of R4. Hence, it would not be necessary to take fresh steps in respect of R4C. Since the right to sue survives on R4A to R4E, the said applications failed to bring them on record is allowed. First rate will be amended. First rate amendment.
Sir, Your Lordships, amended this amendment to writ petition.
ಮಾಡಿದ್ದನ್ನ allow ಮಾಡು.
I shall file the amended writ petition itself.
Seal number 34, Prashant MM. For appellant, my lord.
Who's R4?
R4 is the Nirmala, subsequent purchaser. R5 sold the property in favor of R4, my lord.
ಪರವಾಗಿಲ್ವಾ?
ಇಲ್ಲ.
The application filed for taking out notice on fourth or favorable application is allowed. Favorable application, ಯಾವ ಊರವರು?
Bangalore, my lord.
Favorable application carried out in Deccan Herald ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡ್ತೀರಾ?
Kannadaprabha.
In Kannadaprabha, Bangalore edition. Fixing the date of hearing as so and so.
10th January,
The publication be made on or before.
13th December. Seal number 35, Shri Mohana C.
Yes, Lord, application has been filed, my lord, for appointment of a neurologist, my lord. I might need time to file objections to that application.
What is the petition about?
My lord, this is a order challenging 17/2014, 24. My lord. One second.
Submit, my lords.
My lord,
The suit, my lords, is
the
filed
subject
by
mat-
the suit.
the
is-
subject matter, my lord, relates to a specific performance. There is an agreement of sale.
You are for the plaintiff or the defendant?
I am for the GPA holder of D1. I'm the GPA holder of D1. I'm yet to come on record. My lord, suit for specific performance was filed by the plaintiffs against D1 and D2. The alleged agreement of sale is dated, my lord, 24/1994.
Who's D1?
D1 is the owner, my lord. D1 is the owner.
Ramurthy.
Yes, my lord. He is the owner.
D2 is his son.
And D2, my lord, he's not the part of the agreement. He is not the agreement holder.
D1 is Ramurthy.
D1 is the son of D1. D2 is the son of D1.
Agreement was executed by Ramurthy.
Yes, my lord. Alleged agreement. Now, my lord,
And who are you?
my lord, I'm the GPA holder of D1.
GP holder of?
D1, my lord.
Did you enter appearance as a GP holder of D1 or?
I filed an application under 3 Rule 2 that is yet to be considered, my lord, by the Honorable Court. That is why I'm before this
Exception, my
Honorable
lords,
Court.
I will claim saying that D1 has
No, let me
executed,
complete.
my lords, the joint venture agreement. ಅಲ್ಲಲ್ಲ ಅದು facts ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಅಷ್ಟೇ.
My lord, facts, my lord. Now the,
Not a party in the suit.
I'm not yet a party man because I have filed applications.
You did not file,
I have filed a 3 Rule 2 application, my lord. And D2, who is not a party to the agreement, they have conveniently made him as a party. Along with the suit, they file an application under 32 Rule 4, alleging that D1 is insane, he is mentally infirm, and D2 enters appearance in the court.
how are you related to D1?
My lord, I have a registered power of attorney holder from D1. He has executed a power of attorney in my favor in the year 2018. He gives me all the powers, including the power to conduct any proceedings relating to the scheduled property. My lord,
What is the order that is challenged here?
my lord, order we have challenged is that D2 has been appointed as a guardian of D1. And my lord, D2, he appears on behalf of himself and also on behalf of D1.
Are you claiming a right in this property?
Yes, my lord. Yes.
Then make a separate application. Why do you want to come on record?
I have filed an application, my lord. 3 Rule 2 application is filed.
No,
Now the court
For the
says,
3 Rule 2, you want to come on record as a GP holder.
yes, my lord. Yes.
Since you are claiming a right in the property independently.
Yes, my lord. And
under
not
the
only
GP or
independently.
under the agreement. Seek for impleadment. How can you come on record?
No, my lord, this is a suit for specific performance. My lord, your lordship is well aware. Now, my right over the property, my lord, I am representing only as an agent of D1. I am contesting, I am maybe permitted to contest the suit on behalf of D1.
The court is of the view, D1 is not of sound mind.
Yes.
It is open for the court to appoint anybody as.
Correct, my lord. Yes, yes.
There
Under
is-
what circumstances, my lord? Now, the circumstances, my lord, D2 comes to the court and he files a compromise petition. He consents for decree the suit. D2 on behalf of D1.
If you have a separate agreement under which you are claiming rights over this particular land, your remedy lies elsewhere.
Correct, my lord.
Not in
I am
defending.
not on that, I'm not on that aspect, my lord, because my rights under the order of attorney, my lord, are different, but that including, this also includes as an agent. My lord, as a agent of D1, I'm entitled to protect the interest of D1. D1, my lord, now the court appoints D2 as a guardian and then proceeds with compromise petition.
Let me understand the facts. I file a suit against a particular person.
Also against D2. Yes, ma'am.
That particular person comes to the court by himself. Okay?
Yes.
Now, can the GP holder come and tell the court, no, you can't allow D1 to appear. I have a GPA, therefore I have to represent him.
Well,
Do you have right of such representation?
Yes, my lord, I have a right to represent D1 under 3 Rule 2.
It is the choice of D1 to appoint an agent.
D1 has not appointed.
It is a choice of D1 on service of summons to
Yes.
appoint somebody to represent him in the suit.
Exactly, my lord.
How can the agent come and say, no, I have the GPA, you are bound to consider me as a representative of the D1.
Correct, my lord. Now, here the point is that D1 has not consented. He is not before the court or before the trial court. D2 appears on behalf of D1. There is a collusion between D2 and plaintiffs. D1 is not aware of this transaction at all. D1 files a complaint, files a police complaint before filing of the suit that my signatures are forged. That document I produced before the court. Now D2 admittedly is acting contrary to the interest of D1. Under 32 Rule 4, my lord, he should act for the interest of the
Who's to complain about that?
D1 has to complain.
So D1
D1 is not there, my lord.
D1 is not complaining so far.
D1 has complained. D1 has filed a complaint.
Did he complain to the court?
No, my lord, he's not there because he's mentally infirm right now. After filing of the suit, he's mentally infirm.
And when you got the GPA, he was mentally sound?
Yes, my lord. In the year 2018, he executed a GPA in my favor. The suit was filed in the year 2020. As on the year 2020, my lord.
I think your remedies elsewhere, not in this suit.
Lordship's GPA is entirely
Let
for
him
a
finish.
different purpose.
Let him finish.
My lord, D1 is unrepresented in this case, admittedly, man.
So what is
Whether
the
the
effect?
question is,
That's why I'm saying summons was served on D1.
no, summons was not served on D1. It was served on D2 on behalf of D1.
Servagilva.
D1 may serve, he
D1
has not
and
received it.
Where is the order sheet indicating that it was not served on D1?
My lord, what happens, my lord? Kindly see the order sheet, my lord. Kindly see the order sheet.
No, are you?
Summons is not served. Kindly see the order sheet.
Show me that portion where.
Yes, my lord, summons is not served. My lord, the advocate, my lord, kindly see page 29. That is the order sheet. The first says, advocate for plaintiff filed memo with service of suit summons to defendants. LG advocate is present. He praised time to file objections. My lord, there, my lord, the counsel appears voluntarily on behalf of D1 and D2. D1, he does not file wakalat. D1 doesn't file wakalat. My lord, kindly see. Advocate for D1 wakalat hakilas.
Here there is an intention to. But and otherly, court has appointed a doctor who is in the initial primary health center doctor who is working in that Coromandel initial complex. Court has appointed him. He went to the spot. He gave a finding stating that he mentally is not well and his son is looking after. Then the application was filed. Then we withdraw the suit to file a comprehensive suit. We filed this suit for specific performance. In the specific performance, court permitted us to file a wakalat on behalf of his father because he was mentally infirm. That is why we are continuing. Now he came up with an application to represent the defendant number 1. And court has directed, last may kindly come to page 44, in page 44. In page 44, dated 25/1/2024 order. The plaintiff is present without keeping present the defendant number 1 before the court. DPA holder of the defendant number 1 by name Reddy has filed an IA number 9 by seeking discharge of the defendant number 2, who happens to be the one son of the defendant number 1 as the next friend of defendant number 1. The counsel for plaintiffs has submitted that the defendant number 1, Sri Ramurthy, is mentally not keeping well. Therefore, I asked the alleged DPA holder of the defendant number 1 about where is the defendant number 1. For that, the GPA holder of the defendant number 1 has submitted that defendant number 1 is in his house and he is unconscious. Therefore, considering the submission made by the plaintiff counsel about the mental condition of the defendant number 1, GPA holder of the defendant number 1 is directed to keep the present of the original defendant number 1 before the court for the instruction of the court to ascertain who is looking.
What is IA number 8 and 9?
My lord, I have filed IA number 8, my lord. These applications filed by me, they were kept in abeyance, and the court proceeded to hear on the compromise petition.
What is IA 8 and 9?
IA number 8, I filed to recall the order, posting the matter for keeping those applications on appeal and permit me to argue on those applications. My application, I have filed 2 applications.
You didn't want to keep the defendant number 1 present. You wanted your application to be considered.
No, my lord, D1, my lord, is not in my custody. My lord, now D1 was living alone as per their own documents.
Admit in this before the court that he is unconscious.
Yes, my lord, he is. I mean, that is an admitted fact. I'm not disputing that. The point here is who was to represent D1. D1 is admittedly unrepresented. He has not filed wakalat before the court. My lord, it is my duty as a GPA holder to safeguard his rights. I appear before the court. I file an application under 151 to recall the order wherein he was appointed, D2 was appointed as a guardian. I bring to the notice of the court that he is not the guardian, that he is acting against the interest of D1 because he is entered into a compromise, and that application is still pending. And I also file another application under 32 Rule 9, my lord, for removal of his guardian.
Basically, you didn't want the compromise to go through.
Yes, my lord. That is to safeguard the interest of D1. My lord, D1 admittedly he disputes the
You
document.
have no personal interest in the.
No personal interest, my lord. I am only appearing as an agent of D1.
You don't have.
Now
an
the
agree-
point,
You don't have an agreement of sale, anything in your.
I have a joint development. I have a joint development in my favor. Yes, my lord, I have a joint development. In the year, it was executed in the year 2000.
Enforce.
I'm not, my lord, D1 has not disputed. He has not denied me any rights.
If you have an agreement of sale with you, a JD or whatever, you know what is to be done.
Correct, my lord, yes. I
Enforce
can,
it.
yes, my lord.
You cannot come to the court and insist that you be appointed as the agent of the first defendant, when the first defendant has not come to the court and said, yes, he is my agent.
My lord,
You claim that there's an agency created in your favor. Defendant number one is not before the court accepting the agency. That is your contention.
correct, my lord.
You also contend that you have separate rights over that particular property.
Correct.
Please go and enforce that right. You have no locus in this particular suit.
My lord, I'm only saying that D2 is acting
The
against the
suit was
interest of
free
D1.
performance. Who are the necessary parties?
My lord, the court has to conduct an inquiry before passing an order.
Suit was free performance. Who are the necessary parties?
D1 and the plaintiffs, my lord. The D2 is not admittedly a party. D2 is not a party to the
One is
agreement.
a party. You also admit that he is unconscious.
Yes, my
For
lord.
the question of
The
incoming.
Question of,
parties.
my lord, yes, yes,
Even if suppose D2 was not made a party,
yes, my
it
lord.
was open for the court to appoint D2 as his next friend. Without there being D2.
Correct, my lord. Yes, exactly, my lord. I'll come to that, my lord. It is open for the court to appoint D2 as an as guardian, considering he is a son. My lord, I bring to the notice of the court that he is acting against the interest and it is completely contrary to
what were-
32 rule 4.
What were you concerned? If he has acted against his interest, then D1 is not bound by his act,
My lord,
isn't it?
well, if D1 is unrepresented,
Agreement was with D1.
yes, ma'am.
If D2 comes and agrees for a compromise, D1 will not be bound by it until he has a GPA like you do.
No, D2 is not agreeing for the compromise on behalf of D1. He's agreeing for a compromise on behalf of D1.
It does not in any way make any difference. The agreement. you don't-
Ultimately, I have to challenge this order on behalf of D1. I file
You can't by yourself impose yourself as an agent.
because that is
Have
what,
a GPA.
yes, my lord, that was GPA is coupled with interest.
All right.
Admittedly, that GPA has not been revoked. My lord, I'm only requesting that my applications be considered, whether I'm entitled to come on record on behalf of D1.
Satisfied that you can come on record. In a suit was free performance.
Yes, my lord, it is a collusive suit. It is a admittedly collusive suit, my lord. I'll only bring to your lordships certain documents, my lord. Only rely on certain documents.
Please try to appreciate the point I'm trying to make. That suit, what is the list in the suit? Whether an agreement was executed between plaintiff and defendant
Yes,
number one or
yes.
not.
D1 disputes the
More
document.
than that,
D1 disputes the document. Who is the admittedly a owner?
D1 is unconscious.
Yes.
And you're saying D1 disputes the document. On what basis do you
My
say
lord,
that?
D1 disputes the document much prior to filing of the suit. He files a police complaint. That police complaint is on
Or
record.
D1 is not entering into compromise.
No, my
The
lord,
son
he's
is
not.
entering into compromise.
Yes.
So they get a sale deed from the son. That does not bind D1.
No, but he represents D1. He also represents D1 through permission of the
Not
court.
bind D1, does it? Does it bind D1?
As per the court orders, it does bind D1 as well, my lord.
Where is it said that?
That is what.
Sale is ignored.
Kindly see the compromise. Kindly see the compromise petition. I'll only bring to the notice of the court the compromise
The
petition.
compromise, did the court accept him as
The court has accepted. The court has accepted.
Where is the compromise decree?
My lord, kindly see the compromise petition, my lord. I'm 83, page 83, my lord, annexure D.
You're barking up the wrong tree.
Kindly see para 2, my lord. I'll only request this court to kindly see para 2.
Where is the compromise?
Compromise, page 83, my lord, annexure D. Para 2, the defendants, my lord. They say the defendants, it does not say defendant number 2. Defendants agree that on 24/1994, the first defendant, who is the absolute owner of the scheduled property, executed an agreement of sale the scheduled property in favor of plaintiffs and also swore to an affidavit evidencing the above transaction and also conferred a GPA.
First defendant is not a signatory to this compromise.
Yes, my lord.
So if second defendant is son, enters into a compromise, it does not obviously bind D1.
My lord, that has to be challenged by somebody, my lord. D1 is admittedly is mentally informed. There has to be some person who has to challenge this document. That is
According to me,
invariably me, my lord, because I am the GPA holder.
According to me, in law, plaintiff has entered into a settlement with D2, with whom there was no agreement of sale.
I have no objection, my lord. If it is an agreement of, if it is a compromise between plaintiffs and D2, I have no objection, my lord. But if it is between plaintiffs and D1, my lord, I have an objection.
You are not bound by this compromise. Your rights are completely different. You can't scuttle this compromise.
My lord, even assuming,
This is a
my lord, even assuming I was not a party in this case, my lord, the court under 32 rule 4 was supposed to hold an inquiry whether the person is an
But for
insane.
you to say all this, it's for D1 to come and say there's an illegality committed by the court.
Correct.
I was supposed to be the first defendant. You appointed somebody on my behalf without following the procedure. It's not for an alleged agent to come and say that, no, the agency, I have.
No, agency is not disputed. GPA is not disputed.
You are saying D1 is mentally unwell.
Yes, my lord.
Who's to dispute this agency? Can an mentally unsound
Correct, my
person
lord.
come and say that, no, I did not execute a GPA,
But the D1,
but it is unconscious.
D1 also says that he has, that the plaintiffs have forged the document. D1 also says that he has not
You're
executed the document.
now the mouthpiece of defendant number 1.
Yes, my lord. I want to be the mouthpiece of a, that's why I want to come on record as.
Can be the mouthpiece or not is a question which
Yes,
is be left open.
Correct, my lord. Yes.
It can't be decided in this suit.
Yes, I may be permitted to argue on that 3 rule 2, my lord, and also on 32 rule 9.
You tell me how, on what basis can you come to the court and say?
I have, my locus standi arises
Suit
out
is
of this.
disposed of now?
My lord?
Suit is disposed
No,
of?
my lord, no, my lord. It is still, the suit has been, the proceedings have been stayed because the court is proceeding to decide on the compromise petition. Compromise petition, my lord, has been filed on behalf of D1 and D2. D2 is not there in the picture, my lord. Now, if somebody has to challenge a document.
If they obtain a compromise which is ineffective, they suffer the consequence.
My lord, again, for that, my lord, I have to come on record to say that it is.
What?
Invariably, my lord, the suit is decreed in terms of compromise. My lord, D1 will not challenge the document because he is mentally insane.
Let's assume this compromise is accepted. Does it bind you?
It will bind D1, my lord.
Does it bind you? You are claiming under an agreement of sale.
Also, yes, my lord.
Suppose D1 had suppressed the fact that the suit had been filed against him and not informed you. He had gone and contested the suit on his own, suffered a decree. Will that decree bind you? Merely because you are the agent of D1. Your rights are independent of that agreement of sale with the plaintiff. Let's assume that this gentleman did not inform you and he was mentally well.
My lord,
He executes a compromise deed. Will it bind you?
again, my lord, I am not
Will it bind
insisting.
you?
It will not bind me, my lord. I am not insisting on the power of attorney based on the joint
Don't
development.
want the compromise to go through, that is all.
Yes, my lord. I may be permitted to contest the suit on behalf of D1.
You have no locus standi to contest the suit.
My lord, under 3 rule 2, my lord, I am entitled, I am an agent. And admittedly, my lord, D2 is acting against the interest of D1. I have to bring to the notice of the court. My locus lies with the GPA. GPA empowers me to contest any matters in respect of scheduled property. I am not informing the court that I am a joint development holder. I am only informing the court that I am the agent of D1. And I be permitted to contest the suit on behalf of D1.
It is for the court to decide on as to who's the next best friend.
Yes, my lord.
Whether a son or a.
Let that issue be kept open, my lord. If
That's what the court has done. You have.
No, my lord. Court has already.
You went before the court and said you were the GP holder of D1. Court asked you to keep D1 present. You did not keep D1 present.
D1 is not in my custody, my lord.
That was the order of the court.
That has been misinterpreted, my lord. D1, I informed the court that D1 is in his house. That is in his house, not at my
It's
residence.
open for the court to decide whom to appoint as next friend of D1.
Yes, ma'am.
You have no right to say no, because I have an GPA. I should be appointed.
I'm informing the court that that exercise is not required because I have a GPA holder. I may be permitted to contest the suit. My lord, if that issue is kept open regarding my applications under 32 rule 9 and also 32 rule and also recall application, my lord, that applications filed by me may be kept open, my lord. Admittedly, those applications have not been decided.
It's not my duty to advise you, but I think you're going in the wrong direction. You have an agreement, you have a GPA. I think your remedy is elsewhere. You should have filed a suit making all of them as parties and gone ahead. Then all this problem would have, you could have raised all this issue in your suit. You can't come in this suit and try to secure an order.
My rights have not been disputed by D1. That is my case, my lord. That is why I need not enforce because
somebody has to adjudicate you. There can't be a self-declaration that there is a GPA in your favor. There is an agreement of sale in your favor. There has to be an adjudication, isn't it? Until that agreement of sale culminates in a sale deed, you have nothing. You only have an agency coupled with interest.
No, correct, my lord. Correct, my lord.
And
I
what
have
do you
not
do?
filed 1 rule 10, my lord. I have only filed a 3 rule 2 application. I'm not.
Maybe it's better that you withdraw this application and then do something else.
My lord, if the applications are disposed of, my lord, I have no objection, my lord.
I can't allow such IA 8 and 9 to be considered. Tomorrow somebody will come and say, I am the GPA holder, not you. Consider my application. Then where will the court go on and on? Especially in the light of the fact that D1 is admittedly unconscious. If I as a judge, I would go with the son rather than a third party.
Correct, my lord. Now the court's duty, my lord, under 32 Rule 4, is to find out whether the proposed guardian is acting in the interest of D1. That has not been done by the court.
That there's a provision in CPC saying that the pleader also will have to certify that the compromise, if any, is in the interest of the unsound person, not just the D2.
That has not been done, my lord.
Whether they,
That
if
has not
they-
been done.
If they don't do it, they'll suffer the consequence. You
My lord,
can't
there is
preempt-
nobody to challenge this decree in the event of any decree, my lord.
You don't even have to challenge the decree. Your remedy is elsewhere. Why are you bothered about this suit? You are forgetting your remedy and you are going up the wrong tree. As I said, it's not ready to advise you, but it's your choice. I don't find anything wrong with this order.
My lord, I'll take my chances because my applications are pending in trial court, my lord. Let that be adjudicated. If the court,
Which is the order that is challenged here?
Lord's page 46.
my lord, that is page 46. They have been dismissed for non-prosecution. I may be permitted to argue on these applications, my
No,
lord.
no, it is not dismissed on Lord's non-prosecution.
My lord, it's for non-prosecution.
No, no.
So therefore, my lord, I may be permitted to argue on these applications.
Correct.
On merits, whether I'm entitled, whether I have a locus, let the court decide.
It is not on merits. The
No, Lords.
DNP
Further may kindly be seen, Lords. Though it says, my Lords, non-prosecution, reason, my Lords, is that he was
Maybe.
unable to produce, my Lords, the defendant number 1.
He was not earlier paragraph 20, but today, the said applicant of IA number 8 and 9 by name Sri Somshekar Reddy, that is
Yes.
alleged GPA, has not appeared before the court,
Yes.
nor the defendant number 1 is produced.
Produced before me.
So if he is not present,
Yes.
and if the application.
So, my Lords, he was given opportunity, my Lords, for several
No,
occasions.
only once tane.
No, my Lords.
Because see the earlier order.
Even earlier also.
Allah, see
Even-
the earlier order.
Lords, even on 25.
The earlier order 25 and 2024 asked him to
Yes.
keep D1 present on 17-2.
Yes.
17-2 is not present and it is dismissed.
This is for department, two applications, one is,
Now, in his absence,
another
In-
is recall.
in his absence, the application is dismissed.
Now you cannot file the writ petition here, writ petition itself is not made, that is a.
DNP order ಮೇಲೆ ಇನ್ನೆಲ್ಲ ಹೋಗ್ತಾರೆ?
This writ petition itself is not.
ಇಲ್ಲ DNP order ಮೇಲೆ ಎಲ್ಲ ಹೋಗ್ತಾರೆ? If the applications are dismissed, for non-prosecution, where do they go?
But next, the same court, which court pass an order is the court.
ಅದು ಸೂಟ್ ಆದ್ರೆ, ಐఏಗಾದ್ರೆ ಅಲ್ವಲ್ಲ?
Recalling application ಹಾಕಕ್ ಬರುತ್ತೆ, within 30 days.
ರಿಟ್ ಹಾಕ್ಬೋದಲ್ಲ, ರಿಟ್ಗೇನ್ ಬಾರಿದೆ.
The remedy, my Lords, which is available there.
All other things.
Lords, he should have filed a refund.
Order 9 comes into play when the suit is dismissed, not for dismissing an IA.
Dismiss or default.
Let him be present on that day, let an order be passed in his presence.
We filed a suit of proceed performance.
I understand
And in the earlier proceedings.
I understand the facts, but this order
That will take
is in.
few minutes, I think. So then we filed a suit for injunction earlier. Court appointed.
I understand.
And appointed the second defendant. And suit was that is a bare injunction suit. Withdrawal with liberty to file a fresh suit. Suit for specific performance was filed. But taking into consideration now order 32(2). The suit will not be entertained or maintained unless you make an expert as a party. So we made a second defendant because he is an
No.
expert.
You're right, I am with you, I am with you on the merits, but this application that was filed by him was dismissed in his absence.
Reason is that there was he filed an application earlier. That application was kept pending. And he filed these two applications to recall the earlier order. He has not present. before the
ಏನಾರಾಗಿರ್ಲಿ, this application is dismissed in his absence. Let the court pass an order on whatever it wants in his presence. If there was an order on merits, I would have decided here. There is no order on merits.
But whether this type of application is maintainable, it is a very.
ಎಲ್ಲ
227 proceedings, my respect.
ಅವರೊಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ನಾನು I would have decided, said it's good or bad. The order is one of DNP.
Our contention or not mentally not sound. Court has appointed the second next friend, the son as the next friend. Therefore, you recall that order is his application. That was kept pending.
Lords, may just
Where is
point
the IA
out,
number 8?
may just point out, my Lords, page 33, my Lords, in the order sheet. Page
124,
33.
madam. Annexure L.
Lords, these applications, my Lords, have been filed
But the petitioner herein has filed many applications. One of such application, my lords, is IA number 5 that was filed as early as on, my lords, 15/2/2021 or 22/2021. Lords, there is an order, my lords, at page number 33. The impleading proposed defendant, that is, my lords, the petitioner herein, has filed a memo seeking withdrawal of IA number 5, filed for stay of the suit. The memo is allowed and IA number so and so. Then, my lords, he files an application, lords, that is at page number 35.
A number 8 and Suman.
I number 8, my lord, annexure L, 124.
A number 8.
Page 124.
What is the order keeping in abeyance? Where is that order?
That is so far as, my lords, the impleading applications are concerned.
Which is that order?
My lord, page 142, my lord, page 42.
Page 39 ನಲ್ಲಿ ಇದೆ.
39.
Page 39, the order, my lords, is since the proposed defendant and his counsel are not showing any interest in submitting arguments on their IA number 4, 6, 7, the said applications are kept in abeyance. Case is posted.
So he
for
filed the application to recall this order.
Yes.
He order recall.
No, my lords. He files an application, my lords, 8 and 9.
Yes,
One is appointing me, my lords, as next friend. And another one, my lords, is to discharge me from, my lords, to represent him as the next friend. That is IA number 8 and 9.
Which was the order removing, appointing you as the guardian? You appear for D2, na?
I appear for D2.
Which is the order under which you were appointed as?
There is no order, my lord. They voluntarily appear.
Then where is the question of you making
My
such an
lord,
application?
they appeared in the court and then they said no objection to allow the application. The court did not hold an inquiry under 32 rule 4. That is my case.
Where is the order appointing you as the guardian?
Lords, the order, lords, is at the page number 29.
Page 30, man. My page 29. Advocate for defendant filed memo and submits no objection to allow IA number 1.
Lords,
IA number 1 is filed under 32 rule 4.
page 24 ನಲ್ಲಿ our prayer ನಲ್ಲೇನೆ first prayer itself is that 17/12/2020 order.
What is the memo that was filed on 9/12/2020? Memo and submits no objection to allow IA number 1. What is that memo?
Advocate for defendant number 1 and 2 filed a memo dated February 3rd, no objection to allow IA number 1. IA number 1 is to appoint
D2 as the next friend. Page 61. Page 60 and 61 is the application.
The doctor was appointed, he went to the court, he had given a report. And
Lords, page 60. Page 60, annexure C.
And this you made an application in the year 2024 to recall this order.
Yes.
No, my lord. I filed an application. My first application, my lord, I filed on 8/1/2020.
For what?
My lord, I filed an application for recall. Recalling the
what?
order.
Recalling-
Recalling the order wherein the D2 was permitted to.
Where
be
is that
filed.
application?
No, that application. Not, Annexure F, my lord, 101, page 101, annexure F.
Then why did you make the second application? What happened to this application?
My lord, this application is again pending, man.
Then why did you make another application?
No, because this application was not considered.
So you
and-
make one more application?
No, my lord. Another application was made because my applications were kept in abeyance.
No. What was the order that was kept in abeyance?
The order.
Appointing him.
Yes, ma'am. No, my lord. The annexure F, the IA which I had filed to recall the order, my lord, that was kept in abeyance. That application was kept in abeyance. Therefore, my lord, I filed another application, IA number 8, to recall that order, keeping the application in abeyance, my lord, and permission to argue on that application.
IA 4, 6 and 7 were kept in abeyance.
Yes, my lord.
What was IA 4?
IA number 4, my lord.
This is IA number 2 that you filed for
IA number
recall.
two.
IA 4, my
I
lords,
number
is
4,
under
my lord,
order 1 rule
is
10,
1 rule 10.
Impleading.
IA number 4 is under 1 rule 10, my lord.
1 rule
IA
10.
number 2 is.
You told me that you had not made an application order.
No, I made an application. I'm just informing the court that I am not insisting on that application, my lord. I made an application.
Make up your mind. You want to come under order 1 rule 10 or as the.
My lord, I don't, I'm not insisting on 1 rule 10, my lord. My applications, I number 2.
6 and 7, na?
6 and 7, my lord.
Order 3, rule 2, my lords, is IA number 6.
That is not my
To
application.
contest the suit, my lord, on behalf of defendant number 1.
No, I have filed, my lord, I number 2, that is filed to recall the order.
Application that is filed for recalling.
Yes, ma'am. That is I number 2, page 101.
Please come back to annexure L. L. This is IA number 8, correct?
I number 8, yes, ma'am.
This is to recall the order keeping the applications filed by the applicant in abeyance.
In abeyance, yes, ma'am.
3 applications were kept in abeyance.
Yes, ma'am. 3 applications.
One was IA number
4.
4.
Yes, ma'am.
That is for impleading,
Yes, ma'am.
correct?
Yes, ma'am.
Then IA number 6.
To contest, my lords, the suit on behalf of defendant number 1 under order
Number
3
7?
2. IA number 7, my lords, is to recall, my lords, by which I was appointed as the next friend. That is on 17/12/2020. Well,
You're not giving me correct facts.
I'll not,
In an order passed in 2022, you seek for recalling in 2024.
not the,
that too, my lords, as a GPA holder.
Like impleading on the DLS, sir.
my lord, I am,
He doesn't want, my
No,
lords,
I number
the
8.
pleading application to
my lord, kindly come
be
to
considered.
page 39, my lord.
Hmm.
Page 39. This is the order, which, my lord, I have filed an IA number 8 to recall this order.
Yes.
I number 8 to recall this order.
This order was passed in 2022.
Yes,
You
ma'am.
make an application in the year 2024,
Yes, my lord.
after 2 years.
My lord, I think there was no presiding officer, my lord. That is what I've been told.
The application filed on 4/1/2021, not argued. 2022 kept in abeyance. Now they filed this application for recalling. That was rejected. I was with you only on that ground, that you had not appeared. But if this is your attitude,
My lord, I
that,
have,
in 2022, you are not present, you suffer an order, you keep quiet for 2 years.
no, my lord,
Then when the compromise petition is filed, you wake up, then you seek for recalling this order.
no, my lord.
And then the court imposes a condition on you to keep D1 present. You choose to disregard the court, disrespect the court by not being present on that date.
No,
Why
my
should
lord.
I exercise 227 jurisdiction?
My lord, IA number 4 to 6, my lord, were kept in abeyance. My application
This
under
order
I,
was passed in 2022.
correct, my lord.
You did
My
not raise any
No,
protest.
because, my lord, because my applications under IA number 2, which were filed under 3 rule 2, was still pending, and then the court was hearing on that
So
application.
you decide what you want to do. You have no regard to the procedure of the court.
No.
Whenever you decide, it's time for your application because.
No, my lord, kindly see the
prosecuted-
subsequent order subsequent to that, my lord. After keeping the order in abeyance, after keeping the applications in abeyance, my lord, the court kindly see, my lord. Kindly see the orders, subsequent orders.
2024, you did not take any steps.
My lord, I have appeared in the court. I have insisted on arguing on 3 rule 2 application. That was the first application which was filed by
You
me.
want the court to go by what you ask it to do, not what the court needs to do.
My lord, kindly see the order.
So
sheet.
you will dictate terms to the court as to what is to be done and which I is to be taken up according to your convenience. And when the court passes an order to keep the D1 present, you choose to disregard the court completely and don't go, then you file this writ petition. Why should I entertain the writ petition?
My lord, I approached the court in the year 2020. That was the
But
first application.
It can cut both ways. Be careful when you argue.
Correct, my lord. I filed, sorry, my lord. I filed the first application in the year 2020. My applications were pending. The court gave dates to argue on that application. Subsequently, my lord, I filed another application.
So this is still worse off. 2020, you make an application.
Yes.
Don't do anything till 2022.
No, my lord,
22, the court keeps the orders, application abeyance because you are showing no interest. Thereafter, for 2 years, you again keep quiet. Then make an application, at which stage the court imposes a condition upon you. You don't go to the court at all.
my lord, kindly see the orders in between that, my lord. I filed an application. Kindly see the order sheet from page number 35, my lord. Kindly see the
I am
order
not
sheet from
I'm
page
not
30.
inclined to extend my jurisdiction for a person like you. But he made a false statement saying that we with him. In fact, it is the son.
No, that is not. My lord,
Right,
kindly
right.
see page 36, my lord. Kindly see the
You're
page
trying to
36.
abuse the process of the court.
No,
Like
kindly-
filing an application, disappearing, appearing as and when you want, again disappearing. So the entire process of the court should come to a stall until you decide to come up and say, do this, do that.
No, my lord, my applications were pending, my lord. The court was considering the applications. Kindly see page 36, my lord. I have entered appearance on every date of hearing. The page 36 says, after the order was passed, keeping the applications in abeyance. Not if you lord.
Page 31 may kindly be seen, my lords. Page 31. Kindly see, my lords, this compromise petition was sought to be, my lords, entered into on, my lords, somewhere in year 2020, January.
Guidelines ಅಲ್ಲಿ ವಾಚ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಏನಾರು ಆಗಂಗಿದ್ರೆ ಎದೊಳ್ತಾರೆ.
ಅಲ್ಲ, 23. That is why, my lords, this particular order, my lords, would indicate, my lords, the plaintiff's counsel has filed IA number 2 under order 23 rule 3 of CPC, so and so, so and so. Then, my lords, at that juncture, he enters, my lords, by filing an application seeking impleadment under order 3.
My lord, kindly see page 31.
He
Kindly
doesn't
see page
prosecute
31.
that.
Kindly see page 31, my lord.
This is a watching brief.
No, my lord, kindly see page 31, man. I request this court to kindly see page 31. Now, the plaintiff counsel files a 23 rule 3 along with SPA in the office. The plaintiffs and defendants are present before the court. The office has filed power and IA number 4 seeking implement of applicant. IA number 4 is D3 and IA number 5 under 3 rule 2.
So thereafter you appear,
My lord, I appear.
make an application for stay of the suit.
No, because yes, my lord, I filed an application for stay
Your
of.
intention is clear that you always wanted to stall the.
No, my lord, kindly see the plaintiff counsel, my lord, kindly see this order, my lord. Let me be permitted to read this order. Plaintiff counsel insists for recording the compromise as per IA number 2 filed by the plaintiff. For the submission, the impleading applicant, proposed defendant number 3 has got objections. Plaintiff is directed to file objections to the impleading application. My lord, I appear before the court because they insist on the compromise petition. I'm not next date of hearing, my lord. The plaintiff has filed objections to IA number 4 of the proposed defendant for hearing. My lord, again, my lord, on 15/2/2021.
What do you do? After that, next day, what do you do?
Proposed defendant number files IA number 5 seeking stay of suit and so on so. Yes, my lord.
So you didn't want your application to be considered. You wanted the suit to be stayed.
My lord, I don't have that copy of that stay application.
here,
my lord.
it's
I sought for, there is some.
Next, the impleading proposed defendant number 3 has filed a memo seeking withdrawal of this IA number
Yes, ma'am.
5.
Yes, ma'am.
Filed for stay of the suit. The memo is allowed, IA 5 is dismissed as withdrawal.
Yes, my lord.
So that is the first attempt.
Yes, my lord.
Then what happened?
And then the PO is on leave, my lord, on the next date of hearing. And again, my lord, there's.
Come back to 27/7/21.
And my lord, case advanced, my lord, here, my lord. Here is where.
Please read
6-4
27/7/21 order.
The impleading applicant, instead of addressing argument IA number 4, filed a memo and IA number 6 and 7, seeking to withdraw earlier IA number 3 and instead filing fresh application. Counsel for plaintiff praised time to file objections to IA number 6 and 7.
What is earlier IA number 3?
My lord, that is IA number 3 I had filed under 1 rule 10, my lord. Because specific performance suit, I wanted to withdraw that 1 rule 10 application because I have no locus standi to question. That is the reason
IA number 4 was also for impleading.
No, my lord. I'll correct myself, my lord. IA number 4. Yes, my lord. IA number 4 was for impleading. I had filed only 1 application. That is IA number 4 for.
IA 3 is also for impleading. IA 4
IA 3 is filed under 33 rule 2, my lord. IA number 3 is 3 rule 2.
Then if
IA number 2 is recall
then
application.
if you withdraw IA number 3,
Yes, my lord.
how can you file one more IA now under order 3 rule 2?
No, that is still pending, my lord. IA number 3 rule, IA number 2 of 21 for recall and IA number 3 of under filed under 3 rule 2 is still pending consideration. I did not file a fresh application.
IA 2 is appointing him as the best friend, correct?
No, my lord, no. IA number 2 is to recall the order, appointing him as a guardian. IA number 2. IA number 3, my lord, is filed under 3 rule 2.
IA number 1 is appointing him
Yes, my lord.
as a guardian.
That was allowed. IA number 2 I filed
When
to
did you file
recall
IA
that
number
order.
2? IA number 2 is the compromise petition.
Yes.
IA number 2, no, my lord.
But the order sheet
Compromise.
reads.
Yes,
My lord, according to me, my lord, it's
IA 2 is for compromise. IA 3 is for under order 3 rule 2 filed by the plaintiffs.
sorry, my lord, there is some slight
And
misunderstanding.
IA 4 is for impleading.
IA number 4 is for
5
misleading.
stay.
IA number 4 is for impleading. my
Then
lord.
what is IA 6 and 7?
IA number 6, my lord. IA number 6, I have not filed, my lord.
ನೀವೇ contract ಇರೋದು. The impleading applicant, instead of addressing arguments on IA 4, files memo and IA number 6 and 7. You don't even know which IAs you have filed.
Lord, I'll have to seek instructions.
Then
my lord.
IA number 8 and 9.
IA number 8 and 9, yes, my lord.
So your consistent stand is to ensure that the suit does not go on.
I number 8, my lord, I filed because
don't want to stall the suit so that nothing happens in the suit. You are biding your time, deciding on what to do, instead of filing a simple suit for specific performance on the basis of your agreement of sale. What is the date of your agreement of sale?
my lord, I have a joint development agreement.
What is that?
12/3/2018.
18.
Yes.
Maybe that's become time barred, therefore you are doing all this.
That is the reason.
That is why you are doing all this.
No, my lord,
Of
they
the
have.
father, my lords, he is in a bad condition. Now, my lords, he wants to take
Because the
advantage.
D1 is
so that
not,
if he passes away,
D1 has
that
not
it will
denied
be
any of
open for
my
everyone.
rights under the JD.
The GPA is given to implement the terms and
Joint development agreement, my lord, D1 has not disputed or denied my rights under the JD.
Did you file a
Therefore-
suit against D1 to know whether he disputed or not? As you said, you're giving a self-declaration.
In this suit, my lords,
So
he
since
wants
I
to
had,
say that.
I also had a GPN.
How much money did you pay under the JDA to them?
Under the JD, my lord, the terms were 60-40%.
Not
60%.
many refundable, non-refundable.
And I
deposit.
paid a refundable deposit of 50 lakh.
50 lakhs here. 50 lakhs.
Yes.
You want that 50 lakhs back? That is all, or else you will suffer an order here. You give up your claim under the JDA, I'll ask him to return that 50 lakhs, go home. It's their property, let them do whatever they want.
Our agreement is 1994. We paid 2.55 lakhs.
ಇರ್ಲಿ, ಅವ್ರು 50 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಿಮ್ಮ ಇನ್ಕಮ್ನೆನ್ಸ್ ಇದ್ದೇ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ. ಅದ.
ಇನ್ಕಮ್ನೆನ್ಸ್ ಇದ್ದೇ ಇದೆಯಲ್ಲ, 50 ಲಕ್ಷ ಇದ್ದೇ ಇದೆಯಲ್ಲ. ಅವ್ರು 50 ಲಕ್ಷ ತಗೊಳಂಗಿದ್ರೆ I'll ask them to withdraw. Or else I'll dismiss the petition, enjoy on one more round of litigation
I'll seek instructions.
tomorrow. Advise them if they're prepared to return that 50 lakhs, he'll give up all his claim, file a memo here, matter can be closed. Or else
Very well. Very well.
we'll confirm this order. And hold that you have made every attempt to ensure that the suit does not go through. Don't invite observations from me.
Further consideration, still 36, Parikshit SS.
Short accommodation.
ಏನಕ್ಕೆ?
I have to file objection for the.
ಹಾಕಿದ್ದಾರೆ ಮೇಡಮ್ ನೀವು? ಎಷ್ಟು ಹೇಳಿದೆ ಅದ?
Salaries calculation.
ಕಾಪಿ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, ಅವ್ರು ಏನು ಹಾಕಿದ್ದಾರೆ.
ಅಮೌಂಟ್ ಎಷ್ಟು ಅಂತ ಹೇಳಿದಾರೆ ಮೇಡಮ್?
Persons you lost it. The first page you lost it, person Bharati, what is Bharati? You lost it.
Bharati.
Page number 2 only, total amount you lost is 11,25,000. Then Nagaraj you lost it. For him it is your loss it, your loss it, page number 6.
That's
That is 10,000.
10,12,900.
Then Lakshmi your loss it is my client. That is supposed to get your loss it 9,33,000. Then the another client your loss it just Sanjaya.
933.
Yes, the same amount.
9,36,000.
Yes.
Please.
Perhaps your loss it, this is the calculation we have satisfied now. Now 50% your loss it was on the last occasion offer.
1 lakh is paid to you as of now. 1 lakh is paid to you.
Whatever. the
Lord,
other
every
1 lakh
person-
is the embassy.
My lord, 4 persons have been paid 1 lakh each under the instructions, my lord, as per the orders of this court. Deducting that, my lord, whatever the calculation that has been made,
ರಿಡಕ್ಷನ್ ಮಾಡಿಲ್ಲ ಪೂರ್ತಿ
ಅದನ್ನ ಮಾಡಿಲ್ಲ. ಆ 1 ಲಕ್ಷನ ಮಾಡಿಲ್ಲ. ಆ 1 ಲಕ್ಷ ಮಾಡದೆ ಭಾರತಿ ಅವ್ರಿಗೆ they have arrived at 11,45,379.
If your client is prepared to pay 50% of this,
My humble submission, my lord, is this for your lordship's consideration. For deciding this, I will leave it to your lordships at the end of the day. After, my lord, the inquiry, and at the time of imposing the punishment, what I am instructed to submit is that they sat over the matter, the department. We came before your lordship by way of a writ. And that writ petition, my lord, there was a mandamus issued
to consider that report. Therefore, my lord, still they don't consider. Well, now water have flowed down and it may not be of that consequence today to sit over that mandamus order and all, because it would lead to the, my lord, a kind of this thing. Your lordship may kindly keep two things, my lord, ordering the back wages. I leave it to your lordship. It is not a question of bargaining. It is a question of the capacity of the institution also to pay this amount. In the background of the fact that at the time of suspension, when they were suspended, the allegation is that, my lord, suspension allowance is not paid. That is the only ground on which, my lord, the tribunal has set aside the order of this thing. For that, my lord, we issued them a notice stating that you are not, my lord, staying in the headquarters. You have left the headquarters, and therefore you are not entitled for, my lord, the subsistence allowance as contemplated under CCA rules. Be that as it may, it went on. My lord, to be fair, my lord, a writ petition, my lord, they got an order issued from the authority, that is the state, directing them to pay, my lord, the subsistence allowance. That was the subject matter of writ petition before lordship. That writ petition was dismissed. Thereafter, my lord, these things have happened. That
Despite the dismissal, you did not pay the subsistence allowance.
no, it was not paid. That's an admitted fact. Subsistence allowance during the period of inquiry was not paid.
Then 50% of this is appropriate. And
Right.
other person who's causing you trouble, in one vacancy then ಹೇಳಿದ್ರಲ್ಲ,
This is the list of vacancy alone.
I will ask them to transfer him to some
My lord,
other place.
two submissions, my lord. One is, would your lordship consider, my lord, reducing the DA added? My lord, it would be, my lord, for no fault of mine. Would your lordship, if, my lord, the mandamus order were to be implemented, either they could have rejected my inquiry report or could have accepted.
If you,
No,
if you accept this, if you accept
therefore,
this
I'm
term,
trying to place on record the entire fact before our lordship. We want to buy peace. At that same time, it should not be onerous on our part, my lord, to adhere to whatever the law, your lordship.
Shekhar, they were entitled to this salary. I can't ask them to accept a lesser salary. They were entitled to as a
No,
matter of
salary, last trial salary was entitled to.
Had they
No.
continued in service, this is the salary that they would have got. To deprive them of that. They are being penalized for their activities by asking them to forego 50%.
Yes.
You are being penalized to the extent of 50% by dismissing them despite the fact that you did not have a proof.
Well, I understand. I'm totally in your lordship's hand. The other, my lord, request. Whosoever wants to get a transfer to another institution, they may go and take.
Who choose? You are the one who's saying they're causing trouble.
All of them are causing, even if they go to other institute, they will cause trouble.
Out of 4, only 1 or 2 have, only one has 8 years enough. The others have only 1.5 years.
Yes. One is already retired.
Just 1 or 2 years. The person with the longest tenure, I'll request the department to transfer it.
Then the others would file an affidavit before a lordship during their tenure.
You file an affidavit that you will first pay this, then I'll ask him to do all.
Okay. For that, my lord, the second submission is, my lord, the advocate on record is here, my lord, he may need some, what is the time period that your lordship may contemplate? Because out of the blue, my lord, this man cannot now at one stroke, at 4 weeks or 8 weeks. It would, my lord, the order would become, my lord, in the sense that my client would ultimately end up.
Pay 25% right now, I'll grant you reasonable time for the payment of the remaining 25%.
I'll come back to your lordship, please have it
Next Friday.
next Friday. Oblige me.
Next Friday.
Well, I understand, my lord.
Next Monday, Friday, ನಮ್ಮ colleague ಮದುವೆ ಇದೆ. Monday,
ಹಾಕೊಳ್ಳ
Monday, Wednesday, Wednesday.
Thursday ಹಾಕೊಳ್ಳಿ ಅವರು ಬರ್ಲಿ ಅವರು. Thursday.
Lordship, you also filed that list of vacant posts.
ಫಸ್ಟ್ ಒಪ್ಕೊಂಡ್ರೆ ತಾನೇ ಇವೆಲ್ಲ ಆಗುತ್ತೆ.
ಇದೆಲ್ಲ ಒಪ್ಕೋಬೇಕು, ಅವರು ಕೊಡ್ಬೇಕು. ಟೈಮು ಈಗ 25% ಎಷ್ಟು ಕೊಡ್ತಾರೆ ಅನ್ನೋದು ವಿಚಾರಿಸ್ತೀನಿ.
I'm giving both of them an option to see that the.
My lord, I understand, my lord, I'm totally in your lordship's hand.
There are consequences.
I understand, my lord, we want peace. At the same time, again, my lord, to go back to the department.
It will be a costly piece, both for you and for them.
No, for me, my lord, it will be very heavy fee. They are working otherwise.
ಅವರು ಗೆದ್ದು ಸೋತಂಗಾಗತ್ತೆ.
ನಾವು ಸೋತು ಸತ್ತಂಗಾಗತ್ತೆ.
ಅಲ್ಲ ನೀವ್ ಮಾಡ್ಕೊಂಡು
ಅಲ್ಲ, ನಾವು ಮಾಡಿದ್ದಲ್ಲ ಅದು.
You chose to go against a department. You are not paying them the salary. You chose to terminate this despite the fact that you were aware that they had not granted permission. You chose to, chose to take a risk.
No, we sent them the inquiry report. They did not act upon it. We filed a writ petition.
The fact that you sent a report and asked for their permission indicates that you were aware of the fact that you required their approval.
But I cannot come before your lordship and say that I was not aware of the fact. These people are running an educational institution, an argument by me saying that I'm not on that. I'm on the question of how the department, my lord, is in the hands of those persons. First time, my lord, I'm seeing a counter filed in this. Well, if this attitude continues.
I can look at it from two ways. I can also look at it from the point that you are so big that the department had wanted to cut you down to size and supported the employees.
Nobody's this thing because, my lord, here.
The fact that you chose to disregard the mighty department, which was paying the salaries of all your employees, also indicates your attitude. You are at their whim and mercy for salaries, for their approvals.
Correct.
Yet you chose to say, I will not listen to you. I will do what I want to do.
But therefore, my lord, in this ego clash between the two, my lord, the institution will go to my lord. We would not have initiated an inquiry at all if there were to be no material against them.
50-50. That's all. Or else I'll pass it out on merits.
We'll see. I'll get back correct instructions.
27th, man. 27th.
All right.
27.
Number 37.
This case is appearing for the petitioner, my lord. Lord, I'm appearing for the petitioner.
Yes.
This writ petition has been filed, aggrieved by the order passed
What
by
happened? Are you prepared to give that space? So
I
that
have given my affidavit. I have said all the corrections that I'll do. Now they don't want me to do it. I don't
where is the affidavit that
understand.
you filed?
I have filed the affidavit. It's filed on the 13th of
So you're
September.
agreeable to give us but say a space as required for the fire.
My lords, I am agreeable to do everything, my lords, to make sure they get an occupancy certificate, including the fire, demolition of the unauthorized construction.
Where is the affidavit that you filed?
Lords, the affidavit is filed on 13th of September 2024, my lords. May I read, my lords? May I read, my lords?
1 minute.
From paragraph 4, my lord, should be relevant.
Madam, do you have a copy of this affidavit?
Yes, your lord.
The fire force chief who had come on the other day. Ask him whether para 11, the requirements of his will be satisfied if this is followed.
Lords, paragraph 12, may I request this court to kindly take, my lords, I have given a tabulated column. My lords will take the chart, my lords.
No,
Yes, my lords.
the fire force.
These are the observations made by the fire force, my lords. The present status, the rectification, and the comments which I have, my lord. Some challenges have, but I've said I will do.
Let the fire force chief go through this, and if he feels on the basis of whatever you said,
Yes,
he can grant that NOC. Then we'll take it from there.
I have to do the work.
No, I'll ask whether this is sufficient or you want something more.
All right.
So if he says that this is adequate
Yes.
for granting his NOC,
Yes.
we'll take it from there afterwards.
So just two submissions to make, my lords. I have filed this affidavit without prejudice to the contention based on what my lords had, my lord sounded out to me. that irrespective of the, whether writ is maintainable against a private person or otherwise, they are entitled to an OC. They have filed consumer proceedings against me. I am required to do the same things which the fire force has commented upon. If I am permitted to do the work, my lords, and they say no objection, my lords, I will go ahead. Let the fire force, my lords, give their opinion on it.
Interest is only to ensure that electricity connection is not deprived of the dwellers there.
Yes.
So for that, they brought up this objection of NOC required from the fire force department. Fire force chief said that he can't do it because of XYZ problems. So if he can say that he will be satisfied if this is done to give
Yes.
his NOC.
Yes.
Then electricity supply is assured.
Yes.
Then both of you are there, you can do whatever you want to do with your other litigation. I don't propose to.
There is no
limit
other
their-
litigation, my lords. I do not want this to spill over to that also.
I have
Whatever
a-
is required to get an OC, which will get them, including all other fire force equipment to be
Now
installed, we
get
will
that
do it.
fire force chief, madam. Get that fire force chief who had come to the court. Really?
I have one submission. The fire force officer has given the report based on the direction from this honorable court. And that observations of the fire force officer are compliable and it can be complied. The builder also agreed to comply those fire force officers' observations. Over and above, he is taking certain decisions to demolish certain portion of the property, which is not a subject matter here. And moreover, those are all the matters are subject matter sub judice before the State Consumer Forum.
You
The matter
filed
is
the petition here only for getting electricity connection, isn't it?
Pardon?
You filed this petition.
Ah.
Only to secure electricity connection to all the dwellers.
Yes, my lord.
So that is all this petition be related, confined to.
I'll explain, my lords.
1 minute, my
When
lord.
it
1
comes
minute,
to
let
it,
me
my lords,
complete
I'll
it. Please,
explain.
my dear friend. This affidavit, my learned friend is trying to say there is a deviation in construction, clubhouse and certain other areas, deviation in construction, all those things are to be demolished. Those construction are done by the builder only. Now,
I'll repeat, this petition be confined only for securing an NOC of the fire force department, nothing more.
if
nothing
that were to
less.
be the object, much of.
Any particular date, my lords?
Next Friday.
29.
Please.
Much of it.
Till number 38 for admission. Till number
May I
38.
request on 2nd of December, my lords? 29th, I have
This has
some.
been pending, lingering.
I
on-
understand, my lords,
Right.
they took an adjournment on the last 3 occasions. I was not intimated. Every time I
Say
approached.
you took adjournment.
My lords, I am not.
Four years, they have not appeared before the
Second of
court, my
December.
lord.
My lords, I was not served. They served me notice.
have
I
been served.
expected
Notice
the
has been
order.
served and summons have been
2nd of
served.
December, my lords, if it is not too inconvenient, grateful.
For admission, seal number 38, Shri S.V. Prakash. S.V. Prakash.
My lord, the RFA is posted today. Argument is going on for with regard to maintainability of the appeal. Kindly pass over, my lord.
Seal number 39, S.V. Giridhar. Seal number 39, S.V. Giridhar.
Filed in an RFA, my lords, suit for partition which was filed by the father against the minor daughter. Suit is decreed.
200 rupees court fee ಬಂದಿದೆ. 200 rupees court fee.
No, my lords, he filed a suit for partition paying court fee on the market value of the property, my lords. Actually, the court fee payable was only 200 rupees, my lords. My mother was the absolute owner of the property. My lords, my mother was the absolute owner of the property. My mother died, leaving behind a will. My mother died of cancer. The entire property was left to the daughter. The father filed a suit contending that the will is operative only to the extent of 50% because my wife is the owner only of 50% and she was a benamidar. I own the remaining 50%. So he paid court fee on the value of the property. She is just graduated, my lords, from engineering. She has all along been under the care of her grandparents. So grandparents are
What is the
aged more
report?
than 80 years. My lords, now, my lords, the report is that she has secured an employment finishing her engineering. Lord, she is still a destitute, my lord. She has got 2 old grades, grandparents to take care of.
What is the court fee payable?
Lords, around 50,000 rupees, my lord, 45,975.
She is getting a salary of 21,800.
Lord, she has 2 old grandparents to take care of who have funded her education all her life.
40,000 is not a big sum, Giridhar. For a person who wants 22,000. I think you should pay the court fee and get along with that suit instead of litigating.
Order of the court minutes. She is in great difficulty. Let it be by an order of the court is all my request. She got her employment after the RFA was filed.
The petitioner was the first defendant in a suit filed for declaration and for partition by her father. In a suit filed by her father seeking for declaration and for partition. The father, that is the plaintiff, had paid a court fee of rupees 45,000.
45,975.
957. The time of presentation of the plaint. The suit has been decreed. And consequently, the petitioner who was the first plaintiff and was a minor at the time of filing of the suit has filed this petition contending that she does not have the means to pay the court fee. A report was called for from the Tahsildar regarding the solvency of the petitioner. And the Tahsildar has reported that the petitioner was employed and was earning a salary of rupees 21,800 as per her last pay slip. In my view, since the petitioner is admittedly earning a salary of about rupees 22,000, it cannot be said that she does not have the means to pay the court for rupees 45,957. Consequently, the petition seeking to sue as an indigent person is dismissed. Petitioner is over granted 4 weeks' time to pay the necessary court fee.
Great.
Your Lordship, in previous matter, the date may be any other date. Your Lordship.
ಅದೆಲ್ಲ ಓದಾದ್ಮೇಲೆ ಇರ್ತೇನೆ.
I'll inform you.
Realist. Or you have date of the case.
December 3rd or 4th?
Fourth.
ಅವ್ರು ತಿಳಿಸ್ಬಿಡಿ ಅವ್ರು.
ತಿಳಿಸ್ತೀನಿ.
Silmo 40, Shankar Narayan Bhatt.
For responding.
Wife's total transfer of the petition, the lordship said, if FIR is filed, it will be transferred. That's a copy of the FIR.
Earlier occasion, my lord.
What?
Court direct.
What?
There are.
The Chandrayapatna court to Hunsur court.
This is from
Recent time.
letter.
Recent FIR.
Out of 2 children, the husband withheld them and thrown out his wife. That's the petitioner. And one of the child died recently. And the petitioner went there to attend to the last race and the Haltupaka Hogidaga, she was severely beaten and she was not, right. That's why she lodged the complaint. The in-laws and the husband severely beaten the petitioner and also her mother who accompanied her.
This complaint had been closed, my lord. Recording the statement of the complaint, my lord. On ill motive, this complaint had been filed and the report file mat close madidri. Charge sheet ಕೊಟ್ಟಿದ್ರೆ.
ಇಲ್ಲ ಇದೊಂದು
Subsequently, FIR
had been closed, my lord, by filing charge sheet, my lord. The B report file might close.
You are a health inspector, huh?
Huh?
You are a health inspector.
My lord, I am an health inspector, my lord, in, my lord, Kadballi, my lord. Matliule.
ಬೇಡ ಹೋಗ್ ಬನ್ನಿ, ನೀವೇ ಹೋಗ್ ಬನ್ನಿ, ಸುಮ್ಮನೆ ಯಾಕೆ?
ಲಡ್ ಏನಾಗ್ತದೆ, ಮಗು ಇದೆ, ಮಗು ನೋಡ್ಕೋಬೇಕು. ಲಡ್ ಥಿಂಗ್ ಇಸ್, ಮೈ ಲಾರ್ಡ್, the respondent is ready to take back the wife, my lord. ಅವ್ರಿಬ್ರು ಕರೆದು ಒಂದು ತಾಯಿ ಬಿಡ್ತಾ ಇಲ್ಲ.
ಬಿಡಿ ಸುಮ್ಮನೆ ಯಾಕೆ ಬೈ?
ಮಗು ಇದೆ ಅಲ್ಲ, ಒಂದ್ಸರಿ
2 ವರ್ಷ ಆದ್ಮೇಲೆ ಎಲ್ಲ ತಣ್ಣಗಾಗ್ತಾರೆ, ಆಮೇಲೆ ಸೆಟ್ಲ್ ಮಾಡಲ್ಲ.
ಒಂದ್ಸರಿ ಏನಾದ್ರು ಕರೆದು ಕೋರ್ಟ್ ಮುಂದೆ ಏನಾದ್ರು
ಏನೋ
ಅಡ್ವೈಸ್.
ಈ ತರ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ರಾಜಿ
ಇಲ್ಲ, ಕ್ಲೋಸ್ ಆಗಿದೆ, ಫಾಲ್ಸ್.
ಏನಾದ್ರು ಈ ತರ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ನಿಮ್ಗೂ ಕೋಪ ಜಾಸ್ತಿ ಇರುತ್ತೆ, ಅವ್ರಿಗೂ ಜಾಸ್ತಿ ಕೋಪ ಇರುತ್ತೆ. ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಏನು ಹೇಳಿದ್ರೆ ನಡೆಯಲ್ಲ.
ಒಂದ್ಸರಿ ಅವ್ರಿಬ್ರು ಪ್ರೆಸೆಂಟ್ ಇರ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು, ಒಂದು ಅಡ್ವೈಸ್.
Emotions will be very raw. So this stage is not the stage to talk. ಇದು ಮುಂಚೆ ಏನಾಗಿದೆ ಸರಿ, ಈ ಟೈಮಲ್ಲಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ರೆ ನೀವು ಏನೊಂದು ಆಗಿರೋದನ್ನ, ಇದು ಇಲ್ಲಿ ಮಾಡ್ರೆ ಇನ್ನೂ 1-2 ವರ್ಷ ಮುಂದಕ್ಕೆ ಹಾಕಿದ್ರೆ.
ಅವರೇ ಬಂದು ಹೇಳಿದ್ದಾರೆ, ಏನೋ ಅಲ್ಲೇ ನಾನು ಬೈ ಮಿಸ್ಟೇಕ್ ನಾನು ಇದ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್
And transfer it to Unsur. The wife is before the court seeking for transfer of MC number 57/2023, which has been issued by the husband. ಏನಕ್ಕಿದು?
Dissolution of the marriage.
Dissolution of the
Husband
marriage.
filed.
Before the senior civil judge and James Chandrapatna, the court of the principal senior civil judge and James at Unsur. The wife contends that she is staying with her parents and she cannot travel to Chandrapatna to defend herself. The husband contends that they had 2 children, one among which passed away, and the other son is under his care and custody, and it would also be difficult for him to travel to Unsur. Next part. In my view, since the wife is admittedly residing at Unsur, it would be more convenient for the wife to defend herself at Unsur rather than to come out to Chandrapatna. Therefore, of the view that MC 57/23, which is pending on the file of the senior civil judge at James Chandrapatna, be withdrawn and shall stand transferred to the principal senior civil judge and James at Unsur. So, since the parties are representing the council.
7th January. 7th January. 41? 7th January.
Appear
By the 5.
That's for the respondent.
Petition
on the basis of
the matrimonial proceedings.
Yesterday's matter.
Yesterday's matter.
Only on the basis of the Aadhaar card, my lords, which depicts the address of her sister's house, my lords. She is claiming matter to be transferred to Bangalore. She is a resident of Madikeri district.
And you filed it at Mangalore. You say she is residing at Madikeri. Bani Bangalore, Bani.
Her parents are in Madikeri, my lord. The fact is, she is staying with her younger sister here in Bangalore.
Makla.
Maklilla.
The wife is before this court seeking for transfer of MC 241/2019, which has been instituted by the husband before the first additional principal judge family court, Dakshin Kannada at Mangalore, to the principal judge family court, Bangalore. So the wife contends that she is staying with her sister at Bangalore, and therefore the matter is required to be transferred to Bangalore. The husband on the other hand contends that the wife is a resident at Madikeri, and therefore the transfer to the court at Bengaluru would be improper. In my view, since the petitioner is residing with her sister at Bangalore, it would be appropriate to withdraw MC 241/2019 from the file of the first additional principal judge family court, Dakshin at Mangalore, to the principal judge family court, Bangalore. As both the parties are representing the council, that I have to be present before the
7th January.
Great, please.
Number 42, Shri Shiv Shankar K.
For the petitioner.
But the
Transfer
parties-
petition. Parties are present.
Parties are present before the court as directed by your lordship to ascertain if there is a chance of reunion, because I had submitted that the petition that they are seeking transfer is also referred for mediation, and there is high chances of them living together.
Let's parties present. So many times, let's matter has been referred to mediation.
But they have not agreed. Subsequently, my lords, the wife has filed a divorce petition and my lords, the husband has filed section 9. Both petitions have been transferred to senior civil judge at Hoskote. Now, my lords, this petition subsequently has filed, the husband has filed, appoint the, my lords, a guardian.
Is there a possibility of a settlement? Chance ilva?
Just some time back, she did tell, they spoke for half an hour in the court, and she did tell that if the father is convinced, her father, there is every chance. Otherwise, there is no allegation
But
between each other.
same submission, even
No,
for
she is categorical.
past 3 years, my lords, the same
My lords,
submission, they are.
She is categorical saying no.
I'm surprised. That's what, just now, my lords, half an hour they spoke, and she wants her father to be convinced, because that is the reason she wants to live in Hoskote. She is the only daughter, he is the only son. That is where the disparity. What I suggested is, if a house can be made in KR Puram, my lords, she can also travel to Hoskote, he can go to his work, and they can live together with the child. There is a child involved.
ಏನ್ madam?
Henmogu bere. Why should,
But earlier she has.
I was rejected after marriage. Sir.
Huh?
I was rejected after marriage, not
Was it?
before the marriage.
Mike it.
I was actually rejected after the marriage, sir, not before the marriage.
You're actually what?
I was rejected by them after the marriage.
But now he is accepting you. Can you forgive him?
See, he says things, but it is not going to happen, sir.
Child is, how old is the child?
So just now, as ma'am said, I spoke to him, and maybe the last time I said, if you could convince everyone, your parents as well as my parents, there is a chance, I said, and that was true also. And now I just said it was a talk between ourselves. We have to decide whether we have to stay together or not. It's not the lawyer or the court or someone else who could decide whether.
That's why I'm asking you.
No, he wants it to be in the hall of court. It is not between us. He wants to win the case.
Do you think you can stay with him again? If you have some,
As up to today's talk, I think it's hardly impossible.
you want some more time, or what do you want me to do?
I don't know, sir.
The only case that is before me is to transfer the petition, nothing more. But
Sir,
since it was
please
stated that,
transfer it to the host court, and it's very difficult for me to come from there.
so you're not willing for a settlement as of now.
Yeah,
GNWC itself is referred for mediation. Our actually. That is the reason I said this can
Right.
also be referred, and BMC is equipped with wonderful mediators. I thought there is a chance, definitely from what he says, there is no, per se, no problems between them.
She is not in the frame of mind to settle.
I think her father needs to be convinced, who is in the court, in fact. She's come with the father. Ali school, they are running the school, my lords.
One small bit of advice. Asking for a settlement in the court is different from
Correct.
this gentleman going and talking to the father at his house. There's a difference. They should be satisfied that is
ಅದೇ
genuine.
ನಾನು ಅನ್ಕೊಂಡೆ mediation ಅಲ್ಲಿ refer ಆದ್ರೆ then
ನನ್ ಕೇಳಿದ್ರೆ mediation is not a very conducive atmosphere. There's no level playing field there. There are third parties involved. If he really wants the wife, I think he should go to the parents and then tell them as to what exactly he intends to do.
that's okay. All right, he can go, and there is no
Think-
difficulty, but I think that ಹೋಗಿ ಕೇಳ್ತೀರಾ? He is willing, my lords. To save the marriage, he is willing to do. But if at all she wants divorce, he says, I don't want to.
I'll have it next week. Let him go meet the parents and make one more attempt.
All right. ಆಗ್ಬೋದು.
I think in principle, she does not disagree, but there
correct.
appears to be some mental.
Like I said,
because
yes, yes.
of the attitude that he has indicated towards her. Maybe if he can rectify the fences.
I think both sides, my lords, from what I get, parents' interference is something that, of course, parents are not living with him anymore. He lives alone. But she wants to live with her parents in Hoskote.
Madam, I'll adjourn it once again. Let him come and meet your parents. Then you people will have a better understanding whether this is going to be possible or not. Don't take any decision in a hurry. Nothing is going to be decided here. I'll only decide whether it's be transferred or not. He thinks he wants to make an attempt to convince all of you that he's prepared to mend his ways and take you back. Give him one more chance. Let him come home and then you talk, and then let us see next week.
Let's see, sir.
I'll also urge her to consider, because child's life is there. Ashti, innenilla. Otherwise,
It's up to him as to how he
Correct.
convinces her.
no, it's up to both of them, my lords. Ultimately, if they,
up to him.
somewhere this side, somewhere that side, I think they can.
It's up to him. If he wants, he
Sure.
could convince.
I'll advise. Grateful.
they have not even filed the complaint also, because they want to settle this issue, because so many times, yes.
ನೋಡ್ರಿ ಅವ್ರು ಹೋಗ್ಬಿಟ್ಟು ಅವ್ರೇನ್ ಮಾತಾಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ ನೋಡೋಣ ಏನಾಗುತ್ತೆ ಅಂತ.
ಆಯ್ತು ಸುಮಾರು ಸರಿ final.
29.
Grateful.
Seal number 43, Srimati Kirti Reddy.
My lord, I appear for the petition on this matter. my lord.
Yes.
Lord, this is
Who's
the
for the
draft.
respondent? First time?
Please, lord. Transfer petition, my lord, the petitioner is the wife.
To notice. Petitions will take out notice on the respondent
Yes.
through his counsel in the trial court. Pending the matter will be taken up for final disposal on so and so. Relist on.
In the meantime, my lord,
6th December.
my lord, in the
6th
meantime, a stay will be
What?
granted on further proceedings, my lord.
Yeah, I have granted stay.
Please agree.
Seal number 44. Yashodhara petition.
The wife's petition. She is resident of Dharwad. That's the mutual consent and the GWC was filed by my lords, both of them in Dharwad. But now the restitution comes to be filed in Bangalore, my lords, because he says he's a resident of Bangalore. Now, so take page number 27. That's the
Notice. Petitions will take out notice on the respondent through his counsel in the trial court. Interim stay. Relist on so and so. Inform them will be taken up on the next day.
6th December.
I'm grateful.
Seal number 45, Prakasha M.
Why petition, my lord? The respondent filed the divorce parent, my lord, before the honor principal judge, the
Same
senior
order.
division, T. Narasimhan, my lord.
Same, 6th December. Seal number 46. For the petitioner, my lord. Lord, this is for petition filed to grant for probate. Last will of Korapatti Venkatrao.
Where is the will?
The will is at page 21 to 24, my lord, document number 3.
Who is the petitioner?
Petitioner is the son, my lord, who is the executor of the will. It is stated in Article 4 on page 23. I hereby appoint my son, Anigras Korapatti, as the sole executor of this last will and case. He becomes the
Since
petitioner.
it is undertaken that the petitioners are willing to pay the maximum portion permissible. The issuance of notice to Deputy Commissioner regarding the violation is dispensed with.
Citation.
Issue a citation
I have furnished
to be
the
published
Hindu and Udayavani.
in the Hindu newspaper Bangalore edition and also Kannada newspaper Udayavani edition.
ಇಲ್ಲ Bangalore edition. Udayavani Bangalore edition.
Udayavani Bangalore ಹೇಳಿದ್ದೀನಿ.
ಆಯ್ತು. 13th,
Date of hearing.
10th January. 10th January. 10th. Obliged. Honor before 13th December. Yes. Hearing B group. Silma 47, Shri Srinivas Reddy, are we?
I am for the petitioner, my lord.
Yes,
My lord, yes, in this case, my lord, on 16/3/1996, the petitioner purchased the land from respondent number 3, my lord.
ನೀವು ಗ್ರಾಂಟಿಗ ಪರ್ಚೇಸರ್ ಮೇಡಮ್.
What, my lord?
You are for the grantee or for the purchaser?
I'm a purchaser, my lord.
What is the date of the grant?
It's 1957, my lord.
What is the period of non-alienation?
Permanent, my lord, permanent prohibition, permanent prohibition,
Cheers.
56, 57.
My lord, actually, the petitioner purchased the land in 1996, and the respondent number 3 filed filed appeal before respondent number 2 in the year 2008, my lord. So there is a 12 years difference, my lord. And also, my lord, when Assistant Commissioner passed the order, he himself stated in his order, page number 13, my lord, last paragraph, I mean like last line, end of the page, that is Rome number 1.
Page?
13, my lord.
Page 13 is a sale lead, Amma. Next year.
Annexure, she refers to annexure A,
Annexure A, my lord. Sorry,
second page.
second page, my lord.
I'm sorry, I had the objections. Yes.
Yes, my lord. In this end of this page, there is row number 1. There, the assistant commissioner, he himself stated in the order that ದುರಸ್ತಿ ಟಿಪ್ಪಣಿ ಪತ್ರ ಹಾಗೂ ಆರ್ಆರ್ ದಾಖಲೆಗಳಿಂದ ವ್ಯಕ್ತಪಡಿಸಲಾಗುತ್ತದೆ. ಆದರೆ
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ನೀವು?
that last third line, my lord.
In clause 1.
In clause 1.
Please read the whole thing. Chikkballapur Taluk.
My lord.
Purti odi. Chikkballapur Taluk, Mandikal Hobli.
ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಮಂಡಲ
Mandikal
ಮಂಡಿಕಲ್ ಹೋಬಳಿ ಯಲಂಕ ಎಲೆಗಳಲ್ಲಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 404 3 ಎಕರೆ ಜಮೀನು
ಮೂಲ
ಮಂಜೂರುದಾರರಾದ ಶ್ರೀ ನರಸಿಂಹಪ್ಪ ಬಿನ್ ಕರಿಯಪ್ಪ ರವರಿಗೆ ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ರವರು ಮಂಜೂರಿ ಸಂಖ್ಯೆ
Permanent clause,
38.
Please, my lord.
Permanent non-alienation
20
clause.
years.
Anyway, my lord, it is irrelevant because sale is after 1179.
No, I had raised a doubt. Suppose 56 is a grant. 76, let us say it is over. If the sale was made between 76 to 79, it is a valid sale. If it is after 79, how can it be invalid?
My lord,
4(2) will
section
apply.
4, my lord, is a bar.
4(2) will apply only when the term of non-alienation still subsists even after 79. Suppose the grant was made in 70.
No.
No, that is why 4(2) is there.
No. Section 4(2) is an absolute bar, my lord. Whether condition is there or not,
Please read section.
without, my lord, prior permission of the government.
I have posted similar matters on the 5th. Please read section 6.
My lord,
I
in
don't-
Neelakanti Ramalakshmi.
I don't think, my lord, that honorable court could get any doubt, my lord, with regard to that.
Please read section 6.
I have not brought, my lord, yet.
I need some assistance. I was asking her also. I post similar matters on the.
Because we never got any such, section 6.
Six ಓದ್ತಿರೋ sir, six
No, no, section 4(2) ಓದಬೇಕಲ್ಲ.
Section 4(2) ಓದೋಣ. Section 6 ಓದಿ ಒಂದ್ಸಲ.
Registering officer shall not accept the document for registration. It is clear from the provisions of section 6 that where such transfer is not in accordance with the provisions of PTCL Act, the registering officer shall not accept such a document.
Read the section as such.
Section 6, my lord, I am reading.
Notwithstanding anything in
Case
the
law,
Section Act.
huh? That is not there.
ಹೌದು, notwithstanding ಇಲ್ಲಿದೆಯಲ್ಲ, notwithstanding anything in the registration.
Notwithstanding anything in the Registration Act 1908, on or after the commencement of this act, no registering officer shall accept for registration any document relating to the transfer of or to creation of any interest in any granted land included in a list of granted lands furnished to the registering officer, except where such transfer is in accordance with this act or the terms of the grant of such land or the law providing for such grant. That is, my lord, what the section says is,
Bar for registration in respect of the list of lands are granted to him.
my lord, bar for registration in respect of lands which are shown, my lord, in the list as being.
That is one, except furnished to the registering officer, except where such transfer is in accordance with this act, that is 4(2) permission. Or the terms of the grant of such land or the law providing for such grant. So if the terms of the grant provide for sale after 20 years, it could be registered. Let's assume that the land was granted in 80 for a period of 10 years.
Lord, the my lord, honorable court is inferring, my lord, that there is a conflict between section 4(2) and section 6.
Because section 6 provides for the registration of a document in relation to a grant in accordance with the terms of the grant or the law providing for such grant, then that 4(2) will be read in conjunction only with the period of non-alienation. So, because if the intent was to have a permanent non-alienation clause, the land grant rules even after 69 should have been amended to say whenever land is granted to scheduled caste, there will be a permanent clause of non-alienation except the permission of the government. The land grant rules even as of today say 15 or 25 years. So when the normal land grant rules do not prescribe a permanent non-alienation, can we follow back up on 4(2) and say, because all alienations made prior to 79, which are not in violation of terms of the grant, are valid. The law did not intend to create a further rule extending the period of alienation. If that is a view, then
Lord, I have no difficulty in answering it, Lord, in one sentence. Lord, a section has to be interpreted in the manner in which, Lord, it was enacted. A doubt, if doesn't arise by a bare reading of the section in its grammatical sense, then, my Lord, no doubt should be entertained. If we read section 4(2), Lord, it contains an absolute bar in respect of a granted land, whether it is before or after or whatever period. Any granted land shall not be, my Lord, alienated without the previous permission of the government.
if you see 4(1) talks about an alienation made in contravention of the terms of the grant.
Correct.
So the act is basically meant to repair the alienations.
There are two, my Lord. Section 4(1) contemplates a violation done in prohibition of the grant prior to, my Lord, the act came into force.
No,
It
what
may
I'm
be
trying
40, 50 or whatever.
to say is
4(2), my Lord, is for future.
the
Future, you don't do it at all.
The intent, even if you see the statement of objection reasons,
Please.
is to ensure that no grantee alienates the land in violation of the terms of the grant. The act does not have a problem if the land is being sold
Correct,
in accordance with the terms of the grant.
correct, correct,
So suppose in the year 75 or 85,
correct,
the
correct,
land is granted with a 10-year period.
correct.
After 85, after 95, where is the bar?
No, my Lord, so far as the alienations made prior to 1/1/1979, it is limited. It is limited in the sense because past acts, my Lord, persons who innocently purchase as per the terms of grant should not be punished. That is where section 4(1) is enacted. In violation of the conditions of the grant, if anyone acts, he will be punished. Because he knows that after 10 years or 15 years, or if there is a permanent condition, he should not purchase at all. Still he purchases with open eyes. So he is guilty, he should be punished. Lord, innocent purchasers, my Lord, after the period are all saved. Now, my Lord, act thinks of future, my Lord, protecting the persons belonging to SC and ST. So it imposes an absolute bar
Then how do we
after 1/1/79, my Lord, not to
how do you explain section 6 then? Then they would have simply stopped at that. Year and afterwards, you will not register the lands except with the permission of the government under section 4(2).
I will put
It
it,
stops there. The use of the other two phrases there gives that registering officer the power to register a sale deed if it's beyond the terms of the grant.
there is, my Lord, section 6 gives scope for some thinking, my Lord. There is absolutely, there is some, it gives some scope for thinking about this aspect.
Because in this case, if it's 56, 20 years is over in 76. So between 76 to 79, the sale is valid. How will a subsequent sale be invalid? So if she had purchased 78, she's safe. Because she purchased it in 80, she's in trouble. Salpa, I thought there was some kind of
conflict could be inferred if we read section 4(2) with the section 6. But I can answer that also, my Lord. But let me answer along with the others, my Lord, on the next date.
on 5th. Please see the statement of objection reasons. The act came into being only for the purpose of nullifying those transactions which are made in contravention terms of the grants. Therefore, the principal underlying objective was that whenever a grant condition is violated, we take back the land. And we declare it to be null and void. So the law did recognize it was permissible for them to sell in accordance with the terms of the grant. So why should that restriction not be extended? Why that benefit should be extended even beyond after the act came into force? ಯಾಕಂದ್ರೆ ಹಂಗಿದ್ರೆ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ರೂಲ್ಸ್ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಅಮೆಂಡ್ ಮಾಡ್ಬೇಕಿತ್ತಾನೆ ಅವ್ರು 17 ಆದ್ಮೇಲಿಂದ SC/ST ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲಾದು ಪರ್ಮನೆಂಟ್ ನಾಲಿನೇಷನ್
ಬೇಕಂತಲೇ ಇಲ್ವಲ್ಲ 4-2 ಬಾಸ್ ಅಪರೇಟ್ ಆಗ್ತದಲ್ಲ ಅವರು ಎಷ್ಟೇ ಗ್ರಾಂಟ್ ಕಂಡೀಷನ್ಸ್ ಹಾಕಿದ್ರು.
There's a conflict in that grant rule. After, let's say it is granted in 85, the land rule will still say 25 years. So after 25 years also they can't sell.
They can't sell by virtue of 4-2.
But what should happen to the rule then?
Rule, Milord, Milord, in cases of conflict between the rule and the section should prevail.
If this act becomes operational, only if that principal cause of term of a grant being violated, then if there's no violation of the terms of the grant, then the act itself can't come into operation.
Well, Milord, there is a lot of Milord arguments can be addressed for and against. Let me prepare myself, Milord, fully. Please.
48.
This is a case which was not even granted under the SC/ST Act. It was granted on an upset price, rather more than an upset price itself. There's an interim order of stay.
What is the finding?
I'm sorry, Milord.
What is the finding?
The finding is that, Milord, no, Milord, before I can go to the finding, the respondent before my lords, he is not related to the original grantee at all. Now, that is the first point. Second point is, Milord, whether they belong to an SC/ST caste at all. Number 2. Number 3 is, Milord, whether this land was given to the grantee by virtue of him being in SC/ST or by virtue of some other enactment.
What is the finding on that?
Finding to that effect, Milord, they refer to Mysore land grant rules, saying that no, this was alienated within 15 years. Now, Milord, this is not a land which is granted there at all. 13 people were granted lands. In those 13 people, I am one of them. The other people are not even, they don't even belong to SC/ST. This is not even a land which even comes on the purview of PTCL Act.
Read the finding.
Please, Milord. My lords, may kindly see page 31, my lord. Excuse me. Page 31, I have carefully examined the records and so on, so on, so. As already stated, respondent number 1 and 2 were neither present. As could be seen from the records, in the first instance, the petitioners provided the caste certificate obtained from the Tahsildar, Anikal Taluk, Anikal certifying he belongs to Nayaka community. Now, my lord, I'll just pause there. One is, my lord, this is not his caste certificate. Siddhalingappa is supposed to have gone before the AC court. It's not his caste certificate. It is somebody else's, one Anand's. It is not his caste certificate which he shows.
Who's
number
Anand?
1. I have no idea, my lord. Absolutely no idea.
Yen, madam?
I need time
60.
because I don't have files here.
66 grand, my lordship.
La.
60, page number 67, their own document, my lordship, wherein his caste is specifically mentioned as Naika.
What is 67?
67, memorandum, Darkhast registry extract, my lordship. Page number 67.
That is of Venkatrayappa, not Siddhalingappa. My first contention was that Siddhalingappa and Venkatrayappa have nothing to do with each
My
other.
father, my lordship.
Who's your father?
Third respondent father, Venkatramaya,
La.
Naika.
Venkataramanappa, Venkatrayappa.
Venkatramaya is the grantee.
Venkatramaya
now
is the
say it
grantee,
is
original
alias.
grantee. He is a Naika community.
How do you say that you are the son of this Venkatramaya mentioned in Annexure F?
My lordship,
You have described yourself as son of Venkatramanappa and Venkatrayappa. Illi Venkatramaya anta idu.
Venkatramaya is the original name, my lordship.
What is there to show that you are the son of Venkatramaya?
I will produce.
And my lord, the beauty is this, my lord, I have his voter's ID also.
Or shall I send it back for him to give a finding on this issue?
It can be said. Send it back.
I'll remind it.
My lord, that's fair enough. But may I just point this out, my lord, because it goes to the root of the matter itself, because my lord, remand would again.
Let arguments there. Why do you want
Yes,
to?
my lordship.
The issue is this, my lord. I wouldn't even come in that purview. The issue is this, I wouldn't even come in that purview.
You raise a preliminary ground that he does not belong to scheduled caste, is not the son of the grantee. So let that question be determined first. And you said that the caste certificate was one of Anand.
Please.
And that is so let
As
him.
far as Nayaka community is concerned, I'm not disputing that Nayaka community belongs to ST, but that came only in 1991. It was not granted to him by virtue of him being SC/ST.
It was granted on an upset price because of unauthorized occupation, my lord, that was regularized.
What is there to show that it is unauthorized occupation?
My lord, the grant certificate itself is there.
Then it can't be a granted land.
It's a Darkhast grant, my lordship. It's a Darkhast grant.
If it's unauthorized occupation, I have taken the view that it is not.
Yes, my lord, my lord's judgment itself is there. And that too, my lord, 1966 grant.
Let the authority
Why
take
does
the
it?
call, my lordship.
Why?
All these aspects, my lordship.
Unauthorized occupation relay close ಮಾಡ್ತೀನಿ.
Please.
My lordship,
Unauthorized occupation, I'll close it here.
I will produce, my lordship. I will prepare and.
Realist.
29.
Next Friday. Please.
Next matter, serial
Right.
number 49. Next matter, my lord, serial number 49. May I request for the matter to be taken up next week, my lord.
It's 2016.
Because last date, my lords had heard and suggested that we might have to withdraw the case. Lords, it was heard. But next week, my lords, Tuesday or Wednesday, we will do it.
Realist.
29.
See number 56, my lord. Kindly have it on Monday, my lord. My lord, serial number 60, my lord.
Yeah, the MFA na.
Serial number 60, my lord. Kindly have it on Friday, next Friday.
60.
Yeah, because of my health, I'm not able to.
My lord, serial number 1, my lords, morning I couldn't come, my lords. I apologize, there's an interim order, my lords, which is vacated. Serial number 1, my lord.
No, that's the reason why I got it posted. You have not made an application for a stay, and yet I granted stay.
Oh, yes, yes,
Make an
my lord.
application,
Yes,
then I'll
let
come.
me, my lords.
Connected matter.
22.
Connected matter. Crobber.
No, main.
Main matter 19.
Huh?
19. 50 to 78.
Idurdena?
There. ಗೊತ್ತಿಲ್ಲ ಸರ್.
60 ಅರ್ಜೆಂಟ್ ಆಗಿದಲ್ಲ? Court of
29. 29.
Sir, serial 60? Next, 29.
69.
29, okay. 56,
ಹೌದು ನೀವು ಎಸಿ ಮುಂದೆ ಹೋದ ಹೋಗ್ಬೇಕಲ್ಲ.
Yes. Serial.
ಮೋಸ್ಟ್ಲಿ ಜಾಸ್ತಿ ಕೊಟ್ಟಿರ್ಬೇಕು ಅವರು ಅದಕ್ಕೆ.
Sir, serial number 68 to 68 ಇದೆಯಾ? Serial number 59 ನೋಡಿ ಸರ್. Serial 59.
ಇದೆ.
Sir. Serial number 59 ನೋಡಿ ಸರ್. 59.
59. ಇದೆ. ಮಂಡೇ ಅಲ್ಲ ವೆಡ್ನೆಸ್ಡೇ.
ಬೇಡ ಬಿಡಿ ಅದನ್ನ ಸುಮ್ನೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಸ್ವಲ್ಪ ಅಷ್ಟೇ. ಸಾಹೇಬ್ರು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ. ಎಷ್ಟನೇದು ಸರ್? ಇನ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮೇಡಮ್
ಅವ್ರದ್ದು MF. ನಿಮ್ಗೂ ಅದಕ್ಕೆ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಆಮೇಲೆ ಏನ್ ನಮ್ದು ಬೆಳಗ್ಗೆ ಎಷ್ಟು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಯ್ತು ನೋಡ್ಕೊಳ್ಳೇ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ, ಎರಡೇ ಆಗಿದೆ. ಯಾರು
ಒಳ್ಳೇದ್ ಬಿಡಿ. ಬಟ್ ಇವತ್ತು ಅದು ಯಾವ್ದೋ ಇದರಿಂದ ಅಲ್ವಾ, CPC ಮ್ಯಾಟ್ರಿಂದ ಎಲ್ಲ ಹೇಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಇಷ್ಟು ಮುಗಿತಾ ಇತ್ತು.
Murali. Hello, court officer. Court officer.
ಮೇಡಮ್ ಹೇಳಿ.
Madam ಕೇಳ್ಸ್ತಾ ಇದ್ಯಾ?
ಹಾ ಕೇಳಿಸ್ತಿದೆ.
Madam actually ನಂದು ಅದು ಕ್ಯಾಮ್ರಾ ಲಾಕ್ ಆಗ್ಬಿಟ್ಟಿದೆ madam, ಅದಕ್ಕೆ ನಂದು ಇದು ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಬಟ್ ಅಷ್ಟೇ ನಾನ್ ಹೇಳ್ಬೇಕಂತ ಇರೋದು. ಮೇಡಮ್ ನಮ್ದು ಕಲಬುರ್ಗಿ ಲಿಸ್ಟ್.
ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್, ವಾಯ್ಸ್ ಕೇಳಿಸ್.
ಓಕೆ, ಕಲಬುರ್ಗಿ ಲಿಸ್ಟ್ ಫಸ್ಟ್ ತಗೊಳ್ತಾರಾ ಮೇಡಮ್?
ಇರಿ ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ.
ಓಕೆ
ಫಸ್ಟ್ ಧಾರವಾಡ ಬೆಂಚು, ಆಮೇಲೆ ಕಲಬುರ್ಗಿ ಬೆಂಚು.
ಓಕೆ, ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಮೇಡಮ್ ಧಾರವಾಡ ಲಿಸ್ಟ್ ನಲ್ಲಿ?
ಯಾವ್ದು ಕಲಬುರ್ಗಿ ಧಾರವಾಡ?
ಧಾರವಾಡದು ಮೇಡಮ್.
8 ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಓಕೆ, ಆ ಕಲಬುರ್ಗಿ ಲಿಸ್ಟ್ ನಲ್ಲೂ 8 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಮೇಡಮ್. 8 ಮ್ಯಾಟ್ರೇ ನಂದಿದೆ ಮೇಡಮ್.
ಆಯ್ತು, ಕಾಲ್ ಮಾಡಿದಾಗ ಹೇಳಿ.
ಓಕೆ ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 64 ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ ಮೇಡಮ್? ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 64 ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು
ಅಜ್ಜನ್ ಆಗಿಲ್ಲ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಹಾ ಸರ್.
Court officer.
ರವಿ ಏನೋ ಬೆಂಚ್ನಾಗ ಅದಾರ ಅಂತ ಸಾಹೇಬ್ರು.
ಹೌದಾ?
ಹಾ ಮೋಸ್ಟ್ಲಿ ಬರ್ಬೋದು ಈಗ.
ಓಕೆ.
ಹ್ಮ್.
ಮ್ಯೂಟ್ ಮಾಡಿ ಸಿದ್ದೇಳ ಅಲ್ಲಿ ಕಳ್ಸಿದ್ದೆ ಮ್ಯೂಟ್ ಮಾಡು ಮರೆ.
ಹಾಗಾದ್ರೆ ನೀವು ಬೈದಿದ್ ಕೇಳಕತ್ತದ ನನಗ.
ಇಲ್ಲ ಸದ್ಯ ಸಿದ್ದು ಅವ್ರೇನ್ ಬೆಂಚ್ನಲ್ಲಿ ಇಲ್ಲ. ಅಷ್ಟೇ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Forward bench matter. Serial number 1. Shri S.L. Matti. One number.
Lord, sir, as directed by my lords, the Commissioner Gadag Betageri is present. The the Secretary for the Department of Urban Development is also present, my lords, on VC.
Good afternoon, sir.
I have two affidavits, my lords, indicating as to what all has happened post my lords order, my lords. Copies served on the other side.
This was the commissioner who had not given you any instructions?
My lords, he is saying that he was not well and he had taken medical leave and other things. So. What is that, sir? Yavat kotiddira first. Eradiದೆ. My lords are reading the urban development.
Yes.
Please.
So now you have recommended the proposal for formation of
The layout.
layouts on 13th of November. What is the next stage now?
Lords, I'm instructed to submit that at the earliest, probably within 2-3 weeks. My lords may not take the time as I make a submission. My lords, the permission will be accorded. The commissioner is on the secretary is
Madam.
present. Secretary, madam.
Sir, good afternoon, sir.
What do you propose to do now?
The submission, sir. Proposal is submitted to the government, sir. We are examining it. According to PURA Act, we will accord permission for going about land acquisition for formation of the layouts.
When will that be done?
Sir, please permit me to take 4 weeks time, sir. I will do much before that, but on the safer side, please permit me 4 weeks.
I'll call it after 4 weeks, then let us see what will happen.
Yes, sir.
Because this can't go on forever.
Sir, we are at it, sir. We'll get it done, sir. I will submit the compliance to the honorable court quickly.
And I think you should ask your commissioner to be responsive to the court. He
I
cannot take
already
the court. He cannot take the court and the government advocates for granted.
noted, sir. It has been instructed to him, but show cause notice also is issued to him, sir. Apologies to the honorable court, sir. It will not be repeated again, sir.
The principal secretary, Housing Urban Development Department is present through video conferencing. The commissioner, Gadag Alva,
Gadag Betageri.
Urban Development Authority.
is also present personally before the court. 2 affidavits are filed, one by the principal secretary and the other by the commissioner. In the affidavit of the commissioner, it has been stated that the Commissioner, Urban Development Authorities and Town and Country Planning
Department has recommended the proposal for formation of the residential layout to the government on 13/11/2024, and the matter is seized with the government. It is also submitted by the secretary that in all probability, the government will accord approval with the said proposal within a period of 4 weeks. So in the light of the affidavit and the statements made by the principal secretary, release the matter on
First week of January, I would request 22nd.
4 weeks ಅಂತ ಹೇಳಿದಾರೆ ನೀವು.
Vacation ಬಂದ್ಬಿಡುತ್ತೆ.
Just before vacation ಹಾಕೊಳ್ತೀನಿ.
4 weeks.
We are now in November 23rd.
Please, my lord. 19th or 20th is my request, my lords.
December 20th, madam.
Thank you so much, sir.
Oblige.
Please warn him. ಇಲ್ಲಿ ಬನ್ನಿ. ಹೇಳಿ ನಿಮ್ಗೇನು ಅಷ್ಟು ಕಷ್ಟನೇನ್ರಿ ಅವ್ರ ಹತ್ರ ಮಾತಾಡೋದಕ್ಕೆ?
ಟ್ರೈ ಟು VC ನಲ್ಲಿ ಏನೋ ಕನೆಕ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ.
ಫೋನ್ ಇಲ್ವಾ? ಎಲ್ಲರ ಕೈಲಿ ಮೊಬೈಲ್ ಇರ್ತಾನೆ, ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬೋದು ತಾನೆ.
Kalburgi bench matter for further consideration, seal number 1. RJ Busare.
Lord, appearing for petitioner, my lord.
Yes.
Lordship, on the last occasion, Lordship directed the government advocate, my lord, the AG, to get to, my lord, the information with regard to the salary. What was the salary, my lord, in during 2010? Because, my lord, salary has been stopped from 2010, my lord.
Where is he? Mallarrao.
Alla Mallarrao illante our colleague Arti Patil, my lord, she is appearing. And, my lord, on the last occasion, the government advocate submitted that, my lord, 75% of the government will pay the salary and 25%, my lord, the management will pay. My lord, this scenario was there, my lord, at the time of grant, my lord. Thereafter, my lord, I have handed over, my lord, the order to the, my lord, court officer, wherein, my lord, in the year 2017, my lord, 7, from 75 to it has been enhanced to 85%, my lord. Then, my lord, in the year 2007, again, my lord, it has been enhanced to 100%. The entire salary will be paid by the government only, my lord, not the management.
Where is he?
His colleague, my lord, Mallarrao's colleague, she is asking Passover, my lord.
4 ಗಂಟೆಗೆ ಮೇಡಮ್.
Monday.
ಇಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು, my lord, AG told that, my lord,
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲೇ ಇಲ್ಲ ಸೋಮವಾರ.
ಇಲ್ಲ ಅವ್ನು ಸೋಮವಾರಕ್ಕೆ ಹಾಕ್ಬಿಡಿ, ಯಾಕಂತಂದ್ರೆ ಅವ್ರೇನೋ ಅಫಿಡೇವಿಟ್ ಹಾಕ್ತಾರಂತೆ, ಸ್ಯಾಲರಿ ಎಷ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ ಅಂತೇಳಿ ಅಫಿಡೇವಿಟ್ ಹಾಕ್ತಾರ.
ಮಂಡೇ.
Please.
Seal number 2.
Please.
Madattu, Bantalur.
My lords, I am appearing for respond to 1, 3 and 4, my lords.
Yes. ಹಾಕಿದ್ರ ಅಫಿಡೇವಿಟ್?
My lords, state government has to file, my lords.
ಇಲ್ವಾ ಅವರು? ಮೇಡಮ್.
Serial number 2, Kalburgi bench matter.
ಅಫಿಡೇವಿಟ್ ಹಾಕಿದಾರೆ. ನಿಮ್ಗೆ ಹೇಳಿದಾರೆ ನಿಮ್ಗೆ?
ಏನು ಹೇಳಿಲ್ಲ. ಇಷ್ಟು ಗೊತ್ತಿಲ್ಲ.
29. Seal number 3, Sri Ravi B. Patil.
Here. But last date of hearing, my lord, they have submitted a memo along with the affidavit, saying that, my lord, they may require another 1 year time, my lord, to comply. And this is the issue of, my lord, agriculture, University of Agricultural Science, my lord, where, my lord, promotional avenue, my lord, insofar as the appointees of a stenographer will be deprived of further.
Mantesh Patil.
My lord, in fact, last date of hearing, the madam appeared and submitted that, my lord, she will take the instructions and make submissions today. one more information I received that in respect of the teachers and other staff concerned, except service personnel, all the statutes are formulated and they were operating from the last year. Therefore, it must not need any time. If the government doesn't take any, because the reason is that it will be applicable to all the universities, not only this.
The inner I left take a decision, isn't it? One way or the other.
Adike on the if the government the government if is not in a position to approve and pass, and it is last year only entire the exercise has been done and all the universities have agreed for common statutes, and the also entire bill is ready.
Where is madam?
Madam, has to be not in the
Under section 50 of the Universities Act, the role of government is very minimum. They have to just forward the proposal sent by the universities to the governor. I do not understand. Section 52 is very, very, very clear. Secretary only acts like a postman. He has no independent role either to decide or cancel or do any the proposals, alter the proposals. Last time your lordship had also recorded the in detail what is the role of secretary.
29th.
Passed by your lordship.
29th.
And in past also he had given 3 months undertaking before this on court when contempt was
in the
raised.
contempt proceedings. They have given the undertaking last 1.5 year back. That is why we are insisting that all the universities would get the common statutes.
Yes,
it will help for everyone.
29th.
Seal number 4, Shri Chagashetty.
I appear for petitioner's counsel. My lord, on the last occasion, my lord, they have shown that vacancy position. Last you could recollect, my lord, that batch matter. Lord, that regarding guest lecturers, my lord, last you could recollect.
Who's opposing you?
Lord, in fact, university opposes.
I think it is my mistake also. I came late, so.
Last time government, my lord, submitted that, my lord, the vacancy position. One, my lord, associate professor and 2 assistant professor posts are there. They are sanctioned posts, they are vacant posts, they account to them, my lord. Therefore, there is no difficulty, my lord, in all.
29th.
Provided.
29th, my lord, all this matter, let the government.
No, the government itself has filed a memo, my lord. They-
Our ilvalla.
Yeah,
29th.
29th.
Just ask her to keep you informed. Yen madbeku anta.
Please, my lord, next date.
But practically, my lord, everything is over. You will actually direct them to give the position, my lords. And they have given the position. I don't think there is any difficulty to allow the. You will accept that Rani's case, my lordship. Rangana Jay's batch matter. Identical situation, my lord. More than 2 decades they have worked, my lord. On the last occasion, I supplied judgment also.
29th.
Very.
Seal number 5, Ganesh Subhachandra Kalburgi.
Appearing for the petitioners, your lordships.
Yes.
Your lordships,
Lord,
copy.
I'm sorry, Lord, serial number 4, my lord.
Yen Sudarshan.
Please, my lord. My lord, the university, on behalf of university, my lord,
29th.
Lord, there are 2 judgments, my lord, 198 and my lord, another one is, my lord, as my lord knows that, my lord, constitution bench judgment. Lord, Lord, long, even on, my lord, long passage of, my lord, continuation of.
29th
Lord,
one.
adopt,
29th.
basis. Please.
Seal number 5.
Much.
Lordships, appearing for the petitioners, there is an amendment application of which copy has to be served to the respondents. We will serve the copy, your lordships.
Relist.
29th.
Obliged, lordships.
Further hearing, seal number 6, Shri Ravindra Reddy.
We appear for the petitioner, my lord. This is the case, my lord, wherein petitioners who are working on daily wages since more than 26 years, my lord.
Where's Vijay Kumar?
That's all.
Any other mass bunk? Sarkar.
Lord, maybe 2:30. 29th, my lord, all these matters.
29th. 29th.
Please.
Seal number 7, Shri Mahantesh Pat.
7, 8. 6, 7, 8. 29th.
My lords, one humble request for serial number 8. Let them be given as the last chance, my lords, as already all the arguments have been done
Madam
on both the
Musola,
sides.
Last 3 occasions I have said last chance.
My lords, they had to only reply as regarding the Karnataka public employment reservation in appointment for Hyderabad Karnataka region order, my lords. That's the only point that they have to respond. Rest all the points have already been argued by both the councils, my lords.
Karkond mani avarna. Next time karkond mani neeve.
Obliged, my lords.
29. Passed over matter. Till number 38.
28.
30. SV Prakash.
ಏನಾಯ್ತು ಮೇಡಮ್? ಏನಾಯ್ತು? RF ಏನಾಯ್ತು?
ಅದು ಮಂಗಳೂರಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ. ಮಂಗಳೂರು ಅಡ್ಜರ್ನ್ ಆಗಿದೆ.
Seal number 51, Shri Madhukar Nadi. For petition.
Alright, now, my lord, the petitioner as well as the respondent number 4, 5 and 6. They are claiming, my lord, they are the legal heirs of, my lord, the one original grantee Anjaneya. But these petitioners are also claiming that they are the legal heirs since they are the sons.
We are granting.
Houdu.
When was the grant?
The respondent number, my lord, the 4 and 5 also claiming that they are the, my lord, the wife and sons.
They are also
Another-
claiming.
Please go.
ಅವರು ಗ್ರಾಂಟಿ ಅಂತಾರ?
ಅವರು ನಾವು ಗ್ರಾಂಟಿಗೆ ಸನ್ಸ್ ಅಂಡ್ ಡಾಟರ್ ಅಂತಾರೆ, ವೈಫ್ ಅಂಡ್ ಸನ್ ಅಂತ.
ನೀವೇನಂತೀರಾ?
ನಾವು ಸನ್ ಅಂತ ಹೇಳ್ತಿದೀವಿ, ನಾವು ಸನ್ಸ್ ಅಂತ. ದೇರ್ ಇಸ್ ಅ ಡಿಸ್ಪ್ಯೂಟ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದೋಸ್.
ಒಬ್ರೇ ಹೇಳ್ತೀರಾ ಇಬ್ರು ಹೇಳ್ತೀರಾ?
ಇಲ್ಲ, ಒಬ್ರೇ ಹೇಳ್ತೀವಿ, ನಾವು ಹೇಳ್ತಿರೋದು. Now, the respondent number 6 also claiming that they are the legal heirs. Now, what is happened, my lord? Now, my lord, the respondent number 6, my lord, earlier, my lord, the land has been resumed in favor of, my lord, the respondent number 6. Originally. My lord, thereafter, my lord, the respondent number 6 has sold, my lord, the property to one CN Ravi Kiran anta. He sold it for 1 crore 60 lakhs, my lord. Thereafter, what is happened, my lord, he sought for, my lord, permission to sell the property.
ಯಾರು 6th respondent?
Houdu. Thereafter, my lord, the government has granted a permission that the sale should not be made within, my lord, the 1 year. There is a condition. In spite of that condition, my lord, the 6th respondent sold it, my lord, to one CN Ravi Kiran. He himself has filed a petition for resume the land on the very same ground that I have sold it within a condition, within a period of condition period. Then, my lord, once again, my lord, the land and resumed in favor of, my lord, the 6th respondent. Thereafter, my lord, the CN Ravi Kumar, he has purchased it. He filed a appeal before, my lord, the deputy commissioner. In the deputy commissioner, it has been dismissed for non-prosecution. As on the date of pendency of appeal, my lord, he died. Thereafter, miscellaneous petition has been filed by the legal heads of CN Ravi Kiran before, my lord, the deputy commissioner. It has been allowed. During the pendency of the appeal, now, my lord, the 4th and 5th respondent has filed again, my lord, the resumption of, my lord, the petition, section 5. Seeking that they are the, my lord, the legal heirs of, my lord, the original grantee. Now, what is up, my lord? He filed it, my lord, the original grant, my lord, the resumption of land has been made during 1997-80. Now it has been challenged during 2023 as per, my lord, the PTCL number 9/2023 filed by respondent number 4 and 5 hearing. In that petition, my lord, I have not been made as a party. What is happened? All, my lord, these persons, collusion between the parties, they compromised the petition, saying that I have no objection. Since these respondent number 4 and 5, they are the legal heirs, please restore the land in favor of them. Now, deputy commissioner passes an order As per Annexure L, my lord, kindly see, my lord. How, my lord, these, my lord, the things has been happened.
Annexure
Annexure L, my lord.
L.
Ink page number, my lord, 780. But the PTCL number 9/2023. Got it, man. Now,
Timaka and Govindraju are respondents for.
they
had preferred an appeal.
they are preferred.
Challenging
Claiming
the-
that, challenging, my lord, the order dated, kindly see, but the next, Bengaluru Dakshina Taluku, Kengeri Obli, Kumlugodu Gramada, Sarana number 98/10, 2 ಎಕರೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಉಪಭಾಗದ ಉಪವಿಭಾಗಗಳ ಪ್ರಕರಣ ಸಂಖ್ಯೆ 1979-80 ಅವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು. After lapse of these years, my lord, now he has filed a petition. Now Deputy Commissioner passes an order by considering that, my lord. Next page, ink page number 83, 84 may kindly, my lord, consider. 84. Illi, that the respond number 3 to 6 are not having any objection to restore the land in the old survey number, so and so, situated so and so. Urban district so and so, petitioner by cancelling the mutation orders mutated in the name of the respond number 3
So
to 6.
this order of resumption will inure to your benefit also.
My lord, no, my lord, I am not party to the, my lord, the proceedings.
As to whether you are the legal heir of Anjanaya
Yes, my lord.
or not is to be decided.
They are disputing. They are disputing.
So who should decide who has to who's
My
the
lord, what is up, my lord? I have also produced, my lord, the writ petition before this court, filed, my lord, these respond number 3 and 4. They filed a writ petition before this court, saying that whatever, my lord, this, the land has been mutated in the name of the sixth respondent has to be see cancel anta kelidru. In that writ petition, I filed an application for impleading them, saying that I am the legal heir.
Yeah.
When pendency of, my lord, when pendency of thus my writ petition, my application before this court, application has been allowed. During the pendency of the writ petition, it has not been disposed of. Immediately, my lord, without intimation me, they withdrawn the writ petition. They did not brought all these, my lord, notice before this court. But now, without making me as a party in these proceedings, they filed the appeal. Now, if the land has been restored to these persons, they are in collusively, my lord, they got the land by saying that they are the legal heirs. Now, when my lord, the rival claimants between the, my lord, the parties, my lord, can, my lord, the revenue, my lord, the department or revenue authority can decide, my lord, without, my lord, adjudicate the right of the parties. Since I have also filed a suit for declaration, it is pending before this court. I have made this person as a defendant before the civil court. In that matter, I have sought, my lord, the injunction. Injunction has been granted. Later, he filed a, my lord, the appeal before, my lord, the MA. MA, my lord, my injunction has been, my lord, the set aside. But under these, my lord,
the question is whether you are the legal heir or not.
then it has to be decided. No, no,
It's not yet decided.
it has not been decided.
Is the land resumed in resumed in
Now, my lord, the land has been resumed in favor of the respond number 3 and 4.
order is passed? After the order is passed, did they hand over possession to them?
But now, my lord, they are in possession as per the order of this court, my lord. Order of the Deputy Commissioner.
Okay,
My lords, first of all, my lords, the petitioners herein have nothing to do with the original grantee. Insofar as the records which they have produced along with the writ petition, I have also produced records, my lords, along with my statement of
I have
objection
also produced those documents.
yes.
to say that they are not, they have no relation so far as original grantee is concerned. My lords, may I kindly take my statement of objections.
Nishant, once the order of resumption is passed,
Please,
then the question of restitution will arise
please,
as to who are the legal
Please.
heirs, who is to be given the land. That exercise should be undertaken after this order.
please,
This order saying that you are the only legal heirs
please.
would be premature.
No, my lords, they have nothing to do. If they establish it before this court, my lords, that they are legal heirs, my lords, I have no case. Not even one single document, my lords, to show that they have any relationship with the original grantee. My lords, may kindly take my statement of objections. They have no locus to maintain this petition.
Yes.
Annexure R41, my lords, along with my statement of objections, which is filed on 7/11/2024.
R41.
R41 at page 10.
Yes.
Hanmant Raju, son of Anjanappa, not Anjaneya. Annexure R42 is the Aadhaar card of his wife, Shamla, wife of Hanmant Raju. Annexure R43 is his daughter's Aadhaar card, Purnima, daughter of Hanumantraju. The school certificate, my lords, is at page 13, Annexure R44, where column number 4 is the name of the daughter Purnima. Then 8 and 9 are the names of the parents. Then my lords may kindly take Annexure R45, page 14. This is the voter extract. Next page, my lords, at serial number 356. Kelagada in the second row in the middle. Hesaru D.A. Hanumantraju, Tande Hesaru H. Anjanappa, not Anjaneya. Then, my lords, Annexure R46. This is his own family tree. In the family tree which he has filed before other authorities, he claims Anjanappa had one wife, namely Ramakka, Lakshmamma, Hanumantraju, Anita, Purnima, not Anjaneya, Anjanappa. Then my lords may kindly take the next document which clinches the issue. Page 18, Annexure R47. He himself gives a representation saying that Kata has to be changed in his name because of the death of his father. There he says a different family tree. It is his own document. Then, my lords, now to establish that he is the legal heir of Anjaneya, Annexure R48 is created.
How do you establish that you are the son of Anjaneya?
But I have produced the document for it, Annexure P2, Malad. Annexure P1.
Annexure?
P1.
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 P na D na?
P1, 96.
Annexure P is Malad, the genealogy. Then Malad, the annexure Malad, the P1. Yeah, Mantrayappa.
This is the family tree which I just pointed out to show that was created for the purpose of this case.
Of creation, Malad, with respect to Malad, those aspects, Malad, if he dispute that, Malad, I am not a legal heir.
Anyhow,
I am also disputing that, Malad.
You are before the civil court.
Malad, declaration suit has been filed, but subject to result of Malad, he is also Malad representing before the court, Malad. He filed an impleading application.
The order of reception ultimately inures to the
subject to result of Malad, the suit itself. Because Malad, the revenue Malad, the department cannot Malad adjudicate when rival claimants between the parties, when Malad, the rights has to be determined by the civil court alone.
Therefore, you can't have any grievance regarding the order of resumption. The order of resumption inures to the benefit of the legal heir.
Malad, now
whether you are the legal heir or not is yet to be decided.
I am the legal heir. That is what
that is yet to be decided. If your suit is decreed, you will also get the benefit resumption.
That is what I have filed the start for interim injunction, interim order before this court. That until and unless the suit is determined by the civil court with respect to determination of the rights of the parties, let now they are claiming that they are the legal heirs, the land has been resumed to them. They should not alienate the suit property to any third parties.
You ask for interim order in the suit.
In the suit also, interim injunction has been granted. Now, he has MA has been filed. It has been now cancelled. I have also sought for before this court.
Your interim period is refused by the appellate court.
Please.
So you want me to grant an interim order now?
Now I have sought the petition itself.
So without that order being set aside, you want an interim order?
Please, what?
Without the order being passed in MA being set aside, you want me to pass a fresh order?
No, the appeal, two appeal has been pending before the deputy commissioner. One the appeal filed by the Ravi Shankar, who is the purchaser of the land. Without deciding that appeal, the very same deputy commissioner has passes now these orders.
Why are you worried? This order renews to your benefit. If the deputy commissioner dismisses the appeal, the land goes back to Ravi Kiran.
Please, God. Now it has not been dismissed.
If it is,
now these persons are with
if the appeal was dismissed, then you lost the land. This order is to your benefit. If you are the legal heir.
No, no. The deputy commissioner passes an order saying that he is the legal heir. Now land has been resumed to respond number 4 and 5.
But I will say it will be subject to the ultimate result of the suit that
Please,
you have filed.
Please.
One submission, my lords.
Until
If he is
that
not
minute,
able,
the land should not be, my lord, the alienate to anybody,
Yes.
third parties.
my lords, if he is not able to show prima facie that he is the legal heir by not producing,
I
this
can't-
petition itself is not maintainable, my lords. It has to be rejected on that ground. A person who has nothing to do,
Suppose I reject this writ petition.
please,
The suit is dismissed.
please.
Can I do that?
No, my lords. In the suit, he has not sought for any declaration that he is the legal heir of the grantee.
What is the declaration that he has sought?
He has filed a simpliciter suit, my lords.
But I can
What?
seek, my lord, the amendment of that, my lord, the
For
suit
what?
itself.
I'll place the suit papers on record.
Plain tell it.
The plain tackle.
Plain tackle. Because he has not even filed a suit.
what's
That
up?
that is not a
Plain
dispute.
today.
Plain tandri, plain tilla, very good. I will place it before this court, my lord. Even, my
It
lord,
is recorded.
even, my lord, if I, as on the data.
They say that they are, I have the order copy.
Not for that, my lord. I can seek, my lord, the amendment of, my lord, the plaintiff.
They have
itself.
just,
But
they have-
before that, my lord, kindly see, my lord, the annexure J. Kindly see, my lord, the
Your-
annexure J.
your-
What, my lord,
Your petition according to me is misconceived. If I set
No, my
aside, if I set aside the order of the deputy commissioner, what is the effect?
what effect is that, my lord, the land has resumed to original grantee itself. Now, my lord,
If I set aside this order, that means the sale is valid.
Correct.
Both of you will not get the land. So this order is in your benefit.
now
it
the
does
appeal
not-
is also pending, my lord, where, my lord, the CR Ravi Shankar has filed it. Our appeal pending ಇದೆ.
our appeal.
The order set aside ಏನಾಗುತ್ತೆ?
ಅಲ್ಲ, I do admit, my lord, if the order has been set aside, land our sale did our ಹೆಸರಿಗೆ ಇದೆ ಅಂತ.
ಸುಮ್ನೆ ಯಾಕೆ ರಿಟ್ಟಿ ಹಾಕೊಂಡು
Now, my lord, they should not, my lord, the alienate
That he has to
anybody
file it in the
is-
ಅಲ್ಲಿ ಕೇಳಿ ನೀವು ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದು
ಅಲ್ಲಿ
ಕೇಳಿ.
ಕೊಟ್ಟಿಲ್ಲ, ಅಲ್ಲಿ
Suit, my lords, is for
one submission.
ಅಲ್ಲ ಅಲ್ಲಿ ಕೊಡ್ಲಿ ಅಂದ್ರೆ
But ultimately, my lord, what transpires, my lord, when, my lord, I have filed an application before this court.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡಿದ್ರು ಎಂಟ್ರಿ ಮಾಡ್ರನ್ನ ನಾನ್ ಕೊಡ್ಲಾ?
ಅಲ್ಲಲ್ಲ, ನಾನ್, my lord, I have challenged the order of, my lord, the deputy commissioner. But I have sought entry order on the only operation
simply
that,
say,
my lord, they should not, my
If
lord,
he
alienate.
is able to establish his rights in the civil court, the suit that he has filed, this order will be subject to that so far as
Subject.
the legal heirship of Anjaneya is concerned.
the suit, my lords, is for declaration of title that he is the owner of the property.
That is on the basis of succession.
Please.
Please, my lord.
So if he were to fail there, he fails. If he succeeds, then I can't prejudge that case in the writ petition.
Please. But my objections regarding that he is not the legal heir also may be recorded. Please.
An application for resumption was filed in respect of land bearing serial number 177, practically old number 98/10 of Kumbolgodu village, contending that the land which had been granted to Anjaneya on 22/7/54 had been alienated in contravention of the terms of the grant. The assistant commissioner allowed the application, huh? Where's the order of the deputy commissioner?
Deputy commissioner annexure L, my lord.
The assistant commissioner rejected the said application
Application, my lord.
for resumption. As a consequence, an appeal came to be filed by respondent number 4 and 5 herein, that is Timaka and Govindaraj, contending that the order of the assistant commissioner refusing to resume the land was incorrect. They also contended that they were the only legal heirs of the original grantee Anjaneya, and the land should be resumed in their favor. This prayer of the third and fourth respondent was accepted by the deputy commissioner, and the appeal was allowed. So consequently, the order of the deputy commissioner refusing to resume the land was set aside, and an order of resumption of the aforementioned land was made in favor of respondent number 4 and 5. Next, the petitioners, that is Lakshmamma, Hanmantrayappa, have filed this petition contending that they are the actual legal heirs of the grantee Anjaneya and not respondent number 4 and 5.
4 and 5 and also my lord,
They are
6.
aggrieved by that portion of the order by which the land is ordered to be resumed in favor of respondent number 4 and 5. At the outset, it is to be stated here that an order of resumption would basically inure to the grantee, and if the grantee is not alive, it will inure to the legal heirs of the grantee. Since it is a mandate of the law that on an order of resumption being passed, the land will have to be restored to the grantee or to the legal heirs of the grantee. It is therefore clear that the petitioners cannot be aggrieved by the order of resumption. However, it is a case of the petitioner that since the order of the Deputy Commissioner specifically states that the resumption shall be made in favor of respondents number 5 and 5, this portion of the order forecloses their right over the land in question. Next paragraph. It is not in dispute that the petitioners have in fact instituted a suit in OS
1980 of 2021 before
which they
the
have sought
fourth
for
additional senior civil judge.
declaration that they are the owners of the property on the ground that they have succeeded to the right title in interest of Anjaneya. Unless this suit is, unless there's an adjudication made in this suit that the petitioners are the legal heirs, they cannot obviously have any right to question the order of resumption made in favor of respondents 4 and 5. Learned counsel for the respondent number 4 and 5 submit that there's not an iota of evidence to indicate that the petitioners are the children of Anjaneya, and the documents that they themselves had produced indicate that they are the children of one Anjanappa, who was not the grantee. In my view, this question as to whether the petitioners are indeed the legal heirs of the original grantee Anjaneya or not is a question which will have to necessarily be adjudicated upon in OS number so and so. It will therefore have to be observed that the order of resumption made in favor of the respondent 4 and 5 shall however be subject to the ultimate result of the suit OS number so and so. If in that suit it is held that the petitioners are the legal heirs, then they can put forth a claim for resumption of land in their favor. If however the suit is dismissed holding that they are unable to prove that they are the children of the original grantee Anjaneya, obviously the order of resumption made in favor of respondents 4 and 5 by the Deputy Commissioner under impugned order will subsist. Subject to the above, the petition is disposed.
One submission, madam. Just one submission. My lords, may kindly take page 21 of my objections. Page 21. Just one document, my lords, to show. Page 21. Next year R410.
Yes.
This, my lords, is a form which is printed on 7/12/2011. It is found at the bottom of the page.
Yes.
7/12/2011. Date of issue, my lords, at serial number 12. It says 17/2/1985. This is how the documents are created by the other.
Isn't this?
It's not a duplicate. It cannot be done. This is how the petitioners have come before this court. This is a form which is printed in 7/12/2011. And they have got a death certificate of a person who has passed away in 1985 on a form which is printed on 7/12/2011.
ಇದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ನೋಡಿ ಯಥಾ ನಕಲು ನೀಡಿದೆ ತಹಸೀಲ್ದಾರ್. This is a true copy of.
True copy.
See the last.
Please, my lords, true copy cannot be, true copy has to be on the copy which is already there.
No. If you apply for a copy in the year 2015.
Please.
This is an extract of the entries in the register.
Please.
Whatever is there in the register will be entered. the date on which a certificate is issued. The form that is available in the office, the entries will be made in that and given.
Copy of the certificate itself would be photocopied and be given as a certified copy.
No, they have a printed format. This is an extract. See, this is issued under section 12, 17.
That will be date of registration, my lords, not date of issue.
If
Then
I
the
were-
date of issue would have to be
No,
the
if I were
date,
to apply for a copy of my birth certificate today,
please.
if that is entered in the form,
Yes.
which is printed today,
Please.
but will contain all the details as entered in the register.
Then the date of issue would be today's date.
Now, that's why I said Yata Naklu is the date on which he has given.
Date of issue may kindly be seen, column number 12.
That is a date of issue for this particular registration, not for this.
I'll leave it.
But in Allah, establish
Please.
One submission.
all contentions regarding
One
the.
submission. Till such period, they should not alienate. Then ultimately,
You have not got an interim order. You have not got an interim order in the trial court. You cannot get an interim order here.
One submission. If ultimately, this court, when hold that determination till determination.
You want me to examine whether you are the son or not and then give a finding that you are not the son.
Now, the civil court has to determine my suit is pending. Ultimately, if sold, I will not get any
If
relief
you
from-
if the suit is already filed and if they sell the land, section 52 will be attracted.
See number 52.
Great.
Yes, sir.
Here for petitioner in this case, Lord. Lord, in this case, Lord, the petitioner has questioned the correctness of the order dated 11th October 2023, annexure L, page 113, Lord.
We were granting a purchaser.
Purchasers. Respondent
Grant ಆಗಿದ್ದು ಯಾವಾಗ?
Please. Study. Their claim is that this land was granted on 3/12/1940. 40, but they are not produced any document either before the assistant commissioner or before the deputy commissioner.
What is the finding?
Finding law that assistant commissioner has come to a conclusion that since they have failed to produce the document and also this, according to them, this land was granted in 1940, their submission. So the provisions of PTCL Act is also not applicable, and also there is already the land has been converted. The division bench of this court, coordinate bench, and also the several cases this court has held that once the land has been granted, is a deemed presumed to be the permission has been granted. That is also their Lord. And also, Lord, the land in question is, according to them, 1940, Lord. For a moment, Lord, kindly see page 30, Lord. Is the sale deed, first sale deed, Lord. Page 30. Page 30, Lord. For a moment, sale deed. Even there is no recital whisper with regard to that grant, Lord. This the sale deed has been executed.
I asked you, what is the finding? You
Finding.
said assistant commissioner has given a finding that it is not a granting.
PTCL Act is not applicable.
Land records.
Not like that. Kindly see that
What did the
annexure D, page
What did
67.
what did the deputy commissioner say?
Deputy Commissioner, by applying the provisions of that amendment 2023, is held that this provisions of PTCL Act is applicable. For that, he is
Regarding the grant, what does he say?
regarding the grant, Lord, there is no whisper that with regard to that only on that note. Kindly see annexure L page.
Where is the order of the
130.
assistant commissioner?
Annexure D, Lord, page 67. Annexure D, page 67 is the orders of the Assistant Commissioner. The operative portion at page 69, Lord. Page 16, start from that, Lord. The property in question is
Where is the order of the deputy commissioner?
Lord, annexure L, page 113, Lord. 113, the operative portion is at page 119. Operative portion is 119. The same deputy commissioner, Lord, in respect of survey number 54, new number, because there is a composite property, Lord. In that, the same deputy commissioner has observed that since the property has been converted, that presumption can be drawn that this property has been granted this permission based on that, Lord. In respect of the same survey number, it's a composite property, survey number 54. In that, Lord, in this has held that since the property has been granted converted thereafter the provisions of this PTCL Act deemed permission and this not attracted PTCL Act. The same deputy commissioner in respect of the same property, another property in survey number, same survey number.
The finding of the DC is what? It is a granted land?
Yes. Page 118 minutes.
On what basis does he say this?
That's what, my lord, I'll secure the.
Karatagalu, neither is the revenue department nor they produce that. They are not produced. There are several decisions, my lord.
Share their
Sorry.
opinion.
Would have called for the records, my lord, he didn't do that.
No, Assistant Commissioner,
Deputy Commissioner, he says, my lord, Karatadalli Labhyaviruva Karda. Lord Karda, that is the only document, my lord.
but the Assistant Commissioner had given a counter finding saying that this apart in the absence of the original records, the ingredients required for the purpose so in Pedareddy's case cannot be examined. So he says the record is not available.
Yes, my lord. Even this
From Taluka office, my lord, you should have called for the records, my lord. I'll secure, my lord, if a record grant is genuine, my lord, then my lord, 4(2) is clear violation.
Only one submission, my lord. Kindly see annex,
2006 was
But
the
it's-
annexure here, page 13, my lord.
You have the order of grant with you.
Yes, minutes. Minutes. The assistant commissioner has been.
Where is the order of grant?
Minutes. The grant records have been produced, verified the records, and minutes the deputy commissioner has recorded a finding.
Assistant Commissioner said no records. are
No, minutes. Assistant commissioner has said only we have produced the Xerox copies. So on the basis of Xerox copies, it
For-
cannot be presumed.
Therefore, he should have secured the original
Yes,
records and
minutes.
verified.
But assistant commissioner is rejected. Then deputy commissioner minutes verify the records. Then minutes the deputy commissioner.
If he, Assistant Commissioner has said, in the absence of original records, where did the DC get the original records from?
ಕಡತದಲ್ಲಿರುವ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು
ಇವ್ರು ಹೇಳ್ತಿರೋದು ACCS ಕಡತದಲ್ಲಿ ಇಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಎಸಿ ಅವರು ಹೇಳೋದು Xerox copies ಕೊಡಿ. That is the finding of.
ಆದ್ಮೇಲೆ he says in the absence
No,
of.
let's say the assistant commissioner, page lordship, kindly minutes page and page 69.
Page 68.
Yes, minutes order. Very first instance, there is a
Dala.
so and so.
No, not that. Come to page 68.
Yes, minutes.
This apart, in the absence of the original records.
Then minutes last order operative portion. Secondly, insofar as the grant of land in survey number 54, new survey number so on, measuring 1 acre so and so, is petitioners here have produced only the Xerox copies of the records of certain other documents in support of the grant of land in question, such as Sagolichi to land grant order, etc., and or any other contract documents have been produced. As pointed out by the special deputy commissioner so and so by its order dated line file 2011, merely based on the Xerox copies, this authority cannot take any decision in the matter. This
ಅದಾದ್ಮೇಲೆ next page ಬನ್ನಿ.
My lord, that is
Xerox copies.
citing some citation.
Decision is also there, my lord. Based on the Xerox. copy
Where is
cannot
it
be-
said that he has verified the original records?
Yes.
No.
Then where did the DC get the original records from?
My lord, we have seen the record, my lord, Karda ಅಂತ ಹೇಳ್ತಾರೆ. This is-
Realist.
And also besides that, my lord, the
Records
same
may be
deputy commissioner in respect of the same land, he has dismissed that.
You can
no, no.
verify here.
Yes,
appeal.
minutes.
Lord, if grant is genuine, my lord. it is
Realist.
29th.
not
29.
My lord.
Pendency of the suit, my lord, I mean, the appeal, my lord, they got converted land. Subsequently, my lord, when the appeal is pending before the deputy commissioner, they have purchased the property. 2013, my lord, they have purchased.
Purchase converted land or
Not since
I think
granted,
this-
no, not converted. During the pendency of the appeal minutes, when the matter is pending before the deputy commissioner, they have purchased the property.
Sale.
These petitioners have purchased the converted land.
Grant is
The conversion was made
was the
in
conversion,
2013.
was the conversion made after the purchase or before the purchase?
Before purchase, these petitioners.
Well, let's,
ಫಸ್ಟ್ ಎಲಿನೇಷನ್ ಆದ್ಮೇಲೆ ನೀವು ತೊಡಕಿಂತ ಮುಂಚೆ
ಹಾ.
ಅದು ಕನ್ವರ್ಟ್ ಆಗಿತ್ತು ಆಗಿರ್ಲಿಲ್ಲ.
ಆಗಿರ್ಲಿ.
ನಾವು ತೊಗೊಳೋದಕ್ ಮುಂಚೆನೂ ಕನ್ವರ್ಟ್ ಆಗಿತ್ತು, ಅದ್ರ ಮೊದ್ಲು ಆಗಿರ್ಲಿಲ್ಲ. ಫಸ್ಟ್ ಸೇಲ್ ಆದಾಗ ಆಗಿರ್ಲಿಲ್ಲ.
ಅವ್ನು ಫಸ್ಟ್ ಕೊಂಡ್ಕೊಂಡವನ್ನ ಹೆಸರು ತಗೊಂಡಾಗ ಕನ್ವರ್ಟ್
ಕನ್ವರ್ಟ್
ಆಗಿರ್ಲಿಲ್ಲ.
ಆಗಿರ್ಲಿಲ್ಲ. ಸೆಕೆಂಡ್ ಸೇಲ್ ಮತ್ತೆ ಥರ್ಡ್ ಸೇಲ್ ಆದಾಗ ಆಗಿತ್ತು.
ಕೊಂಡ್ಕೊಂಡಾದ್ಮೇಲೆ ಕನ್ವರ್ಟ್ ಆದ್ರೆ there is nothing. If you had bought converted land, then that argument would be there.
But
When the
these
government is
petitioners are concerned, this purchase this property after conversion, and
You will-
also now this property has come under the judicial.
Yes, you will suffer the consequence of the first alienation, not the second alienation.
And also, my lord, one submission, even in the sale deed, there is no reference with regard to that grant, my lord. Kindly
ಅದು
see.
ಬರೆಯೋದೇ ಇಲ್ಲ sale deed.
ಯಾವ ಕಾನೂನು ಹೇಳುತ್ತೆ
First, ಅಲ್ಲ ಈ ಅದ್ರಲ್ಲಿ
ಯಾವ ಕಾನೂನು ಹೇಳುತ್ತೆ ಬರೀಲೇಬೇಕು.
first, my learned friend is taking the contention that this
No.
land has been granted
Tell
in
me.
the 1940.
Which law says that the order of grant should be mentioned in the sale deed?
Lord, this mode of acquisition of the land, how their owner becomes this property, to that extent, at least they have to mention that. The sale deed annexure A page 30,
ಅದೆಲ್ಲ
there is
weak.
no whisper with regard to that.
That is a weak argument.
Number 53.
Yeah, wait.
Sixth.
We have the petitioner. This is a purchaser's petition, my lord. The deputy commissioner, my lord.
File statement of objections.
My lord, this is a matter covered by the full bench judgment of this honorable court. The deputy commissioner goes through the records. He finds that it is a tenanted land and that the father of the respondent 4 to 11, my lord, was a tenant, has been conferred occupancy rights under the Karnataka Land Reforms Act.
Form number 7.
Yes, my lord.
Yes.
That is the finding of the
Lord,
deputy commissioner.
I'll mail out next week, any date may be given.
Like if it's form number 7 other than
Allah, if that is so, my lord, I'll
list.
One date may please be.
29.
6.
bless.
So number 54, Srihari.
This is a case where Millards granting under Roma food scheme. It is recorded by both the tribunals below. I have produced the list of authorities on last occasion, Millards. It's covered by decision of this honorable court, which is confirmed by the honorable apex court. And there is a delay of around 40.
ಎಲ್ಲ connected matter ಯಾಕೆ?
ಎಲ್ಲ ಗ್ರೋಮೋರ್ scheme. More matter ಒಂದೇ ಆರ್ಡರ್ ಇದ್ದು pertaining to same order. Other matters are grants under Gromor food scheme.
ಅದು ಒಂದೇ ಆರ್ಡರ್.
ಒಂದೇ ಆರ್ಡರ್ ಇರೋದು 54, 54.4 and 54.5 minor.
54.4 and 5.
54 first matter, ಅದಾದ್ಮೇಲೆ 4 and 5 ಮೂರ್ matter.
The other 3 are different but the same principle.
In 54.3 also.
54.1 I appeal for the petition. My lord, in 54.3 also, there is a claim of the Gromor scheme property.
No, my lord, I'm for respondent. It is not comes under Gromor food scheme. Not very neat.
How do you say it's a Gromor food scheme?
It is there in the record. It is, they're referring to other matter, not my matter. Namdralli grant certificate as well as orders of the ACDC, there is a reference that it is a Gromor. Kindly see first matter, my lord, page number 45. This is the Darkhast memorandum. There is a clear finding that it is under Gromor food scheme. You lordship can see from 42, my lord, page number 42. Angami Sagavali Chiti, 5 ವರ್ಷಕ್ಕೆ ಅಂತ ಕೊಡ್ತಾರೆ ಫಸ್ಟ್ 42 ಅಲ್ಲಿ. ಅದಾದ್ಮೇಲೆ ದರ್ಖಾಸ್ತ್ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 48 ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. 48 ಅಲ್ಲಿ ಸಿ ಸ್ಮೆಲಾರ್ಸ್ ಮಿಡ್ಲ್ ಅಲ್ಲಿ ಕೈಯಲ್ಲಿ ಬರ್ದಿರೋದು 47-48ನೇ ಸಾಲಿನಲ್ಲಿ GMF ರೂಲ್ಸ್ ನಲ್ಲಿ ಪಡೆದು ಅಂತ ಅಲ್ಲಿ there is a reference and this has been recorded by the AC as well as DC. And even in the page number 49 also there is a reference 47-48 under GMF scheme anta. Lordship may see page number 20, my lords, impugned order. Even the impugned order, the DC refers it. Page number 20. ಇಲ್ಲ ಸರ್ 4 and 5. 50 pound. Kindly see page number 20, my lords. Typed copy 55 alliದೆ. ಅಲ್ಲಿದೆ. Lordship may see 56 minutes. In the English portion. They submitted with sketch and margin for kind perusal. Land was granted to the applicants during 47-48 under Gromor food scheme, GMF. Lordship may also see page number 20 minutes for a moment.
There was no condition here in this Gromor food scheme. And this was not with reference to people belonging to depressed class. Anybody who was interested?
That is
How
what-
can you bring it within the granted lands definition?
that is the view of this honorable court. I have placed the citations also.
No, the word used for granted land is any land granted to a scheduled caste or a scheduled tribe person. Now, this 1942 order and 1943 order is with reference to anybody who's willing to take up cultivation. It has got no reference to the caste of the people who come forward to take up the land cultivation. It is to be on a lease for a period of 5 years with the option for them to purchase. There's a concession for the revenue that is payable. How can you call it granted land? I will come to the judgment afterwards. The rule relating to the grant of land under the Gromor food scheme does not contemplate granting any special concession to persons belonging to scheduled caste or scheduled tribe. It does not prescribe any period of non-alienation. The order of the 11th of April 1942 does not indicate of anything. It only says you will be given the right to cultivate the land. And there'll be a concession insofar as the assessment is concerned for the first year, second year, third year, and fifth year. There's no question of any upset price being granted because the land is not being given to you absolutely. You are given the right to cultivate. At the end of 5 years, you are entitled to purchase it. 43 notification says that you will be able to pay the upset price as on the date you were put in possession, not as on the date of completion of the 5 years. That is all. So this is not a grant to the depressed classes.
Page number.
No, 43J will never apply here. Correct. The order of the government of the year 1942 did not prescribe any restriction for the alienation of the land. It only permitted anybody who comes forward to occupy a land and cultivate it to raise more food for the state will be given that permission. So that is because in the normal rule, whenever okay, let me put it like this. Under the normal land grant rules, a certain percentage no, I will put it like this. The definition of a granted land would bring within its definition only those lands which are granted to a person primarily because he belongs to scheduled caste or scheduled tribe. If the land is granted to him without reference to his caste, it cannot be a granted land.
It is a granted land occurring under the Act. The last one is VDA grants. That is also a granted land. There are any number of them. And another two which I have not reported, I have produced along with my.
Mundaraju's judgment, page number 58, my lords, in my compilation. Your Lordship may. This issue has been answered, my lords. Page number 58, my lords. That is the third division bench judgment. Page number 58, it starts with 49. From paragraph 13 and onwards, the same issue has been answered. Paragraph 13, my lords. May I read, my lords?
Division bench says it is not a granted land.
All three division benches.
Division bench. ಯಾವ ಕೇಸಲ್ಲಿ ಕೌಂಟರ್ ಹಾಕಿದ್ರ
54 is 54.2 ಅಲ್ಲಿ 54.2 ಅಲ್ಲಿ even with reference to 43J also, there is a discussion, my lords, at page number 43, at page in the compilation. Page 43, my lords. Num compilation. It starts with 42, my lords. 42, paragraph 23. We have considered the judgment in case of Shivlingam Ante. Alinda start agi. In the next page, it is discussed. about 43J. Last 3 lines, paragraph.
ಯಾವ್ದು ನಿಮ್ದು ಯಾವ್ದು? ಯಾವ ಜಜ್ಮೆಂಟ್? ಕೌಂಟ್ರಲ್. This is Justice Ashok Kanagis. No, but this is a division bench. The judgment that is relying upon is division bench. ಎಲ್ಲಿದೆ ಗುಂಡೆಯಿಂದ ಎಲ್ಲಿದೆ? ಕೊಡಿ ಯಾವ್ದು? This division bench is clear. Like I just now said, that is a view taken.
Division bench, judgment.
Yeah, which is ಎಲ್ಲಿದೆ ಗುಂಟೆಯನ್ ಕೇಸ್? ಯಾವ್ದ್ರದ್ದು ಗುಂಟೆಯನ್ ಕೇಸು ಶ್ರೀರಿ? Which is that Guntaya's case is referring to?
We have not produced that, my lords, here. In compilation, these 3 judgments are passed following the several division bench.
He says division bench is contrary to the Guntaya's case.
It is confirmed by the Honorable Apex Court, my lords. First judgment of this Honorable Court is confirmed by the Honorable Apex Court. Kindly see page number 25, my lords.
No, Supreme Court according to you has said that a land grant under the Gromor Food Scheme is a granted land as defined under the PTCL Act. Good. This is under the Land Revenue Amendment Rules 1960. Certain lands were granted to members of scheduled caste, scheduled tribes. Initially, these lands were given to them on temporary lease. So this was a grant under the land grant rules. No. Correct. No. This Supreme Court does not deal with Gromor Food Scheme. ಹೇಳುತ್ತೆ Gromor Food Scheme. ಓದಿ. 43 division bench has held 43G will have no application when it is a grant under the Gromor Food Scheme. Unless you tell me Supreme Court has said even a land grant under the Gromor Food Scheme is a granted land as defined under the PTCL Act, I can't accept this judgment. In this judgment, there is no reference to the Gromor Food Scheme. Nanalla, it's already decided in Faraching and he says this has also been confirmed by Supreme Court. Witnessed. Yes, Thursday.
My lords, I appeal for the petitioner, my lord, in 54.1. My lords, on the previous occasion, the government was instructed to secure the original records.
Let us see. All these cases, Gromor Food Scheme, after 42. Now, in the first matter that I had, there is a reference to the fact that so that and these 54.4 and 54.5 relates to the same order. So that is Gromor Food Scheme only. The other two will.
54.1
This court has come to a conclusion whether it is a grant or more scheme or not. And what is we have written the.
ನಿಮಿಷ ಅವ್ರು ಹೇಳ್ತಿದಾರೆ ಇಲ್ಲಿ.
It is a grant whether it is a grant under to a debtors plus for free of cost.
Is it under the Gromor food scheme?
It is not under Gromor food scheme, but we have the observations. We have
It
the
is.
observations in the AC code and DC code.
ನೋಡಿ ಮೇಡಮ್ ಅವ್ರದ್ದು 54.3. ಇವೆರಡು ನೋಡಿ ಸರ್, 54.1 and 54.2 and 54.3. Get the records and see whether it is.
Correct. There the AC code.
ಹೇಳಿ ಅವ್ರು ನೋಡಿ ಹೇಳಿ ಅಂತ ಇದ್ದೇನೆ ಅಷ್ಟೇ.
Clearly they have been part of.
They have not.
In Thursday,
In this matter,
29.
29.
coming Thursday.
Thursday, 29.
ಯಾವ್ದು ಬೇಕಾ?
Stays.
ಇಲ್ಲ,
Any day next
ಮಂಡೆ ಹಾಕೊಳ್ಳ?
ಅಲ್ಲ, ಈ ಮಂಡೆ.
ಅವ್ರು ಬೇಕಿರೋದು ನೀವಲ್ಲ, ಅವ್ರು ಇಂಪಾರ್ಟೆಂಟ್ ತಾನೆ.
Monday.
What she says is of material, isn't it? If she says Gromor food scheme,
29.
Tuesday.
Interim.
What has happened, my lord?
ನಾನು ಇಷ್ಟೊತ್ತು ಕೇಳಿದ್ದೀನಿ, ತಿರ್ಗಾ ಎಲ್ಲ ಫಸ್ಟ್ ಇಂದ ಕೇಳಂಗ್ ಮಾಡ್ಬೇಕು. 7th ಅಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ತಿದ್ದೀನಿ, ಕಮಿಂಗ್ ಟ್ಯೂಸ್ಡೇ.
26.
Interim order in all the matters needs to be extended. Interim order.
ಫೈಲ್ ಮಾಡಿ ಆಫೀಸಲ್ಲಿ.
Serial number 65 minus interim order extended.
ಮಾಡ್ತಾರೆ.
Mandai interim order.
ಟೈಪ್ ಮಾಡಿಸಿದ್ರೆ ಆರ್ಡರ್ ಕೊಟ್ರಲ್ಲ,
Tuesday. ಮಂಗಳವಾರ.
26. ಫೆಬ್ರವರಿಗೆ ಹೇಳಿ. Dates ಇದೆಯಲ್ಲ, 8 copies ಬೇಕು. ಗೊತ್ತೇ first.